Good morning, good evening, good afternoon, good whatever you are doing, wherever you are. This is going to probably be a long stream. It's probably going to be a boring stream. In this stream, I'm going to read the state's brief. This is the appellee's brief, not the appellant's brief. This is the opposition to Earl's brief. And I just want to point out, I know I'm going to get a million questions, but hopefully people start from the get and they don't try to jump in late and start asking stupid questions that I've already dealt with at the beginning of the stream. I know they will, but if they rewatch this, maybe they'll feel stupid for having done it. Time is linear. It doesn't start when you join the stream. If the stream is already in progress, rewind. So the first thing that I want to note is that the brief from the state was received on the 22nd, along with a new motion for extension of time to file the brief. And the motion was denied. I didn't see these when I first covered it. These hadn't shown up. But the motion was denied. It was denied on the 23rd, the day after. The case is ready to be set. The case is at issue. And you'll see up here, the state's brief is received. Received is different than filed. See, brief filed, amended brief filed. Filed is different than received. The state's opposition is received. You'll notice here that this is accepted, it is received, it is not filed. Now, what that means is that the judges aren't going to review this. So everything that I'm doing today is for me, not for you. That might make me a dick, and that's fine. You are what you eat. But boom. That might make me a dick, but I want to understand if the state has a good case. Well, if Earl's case is as good as I first thought. So I'm going to be reviewing this to see if I was the judge. And again, I don't let me really set the stage here. I'm not a Texas attorney. I have never done any appellate work in Texas criminal courts. I've never done any criminal appellate work, period. I've done some civil appellate work, but never criminal, and never in Texas. So, take this with as many grains of salt as necessary. And I want to state, for those of you who are rooting for Earl has a long shot chance before I read this. So it's only going to get worse from here. It is a disfavored motion. The Court of Appeals does not like to meddle inside of an already finished trial. The Court of Appeals wasn't there. They don't know how things were going. So it's a highly unlikely motion to succeed in the first place. I just want to be very clear about that. So, and just because I have state phone numbers and addresses up here, I swear to God, as soon as I start recording, the goddamn rooster. But this is probably going to get the stream taken down just because state addresses and phone numbers are up here, because YouTube's algorithm is pure stupid bullshit, and it's going to detect a government address and a government phone number and a government email address as protected personal information because it's retarded. All right. Goddamn rooster. All right. So the state isn't requesting an oral argument. That's interesting. So fucking rooster, I swear to Christ. My best guess is that they think, and I haven't read this, I don't know. My best guess is they think that their arguments are good enough on paper that they don't think oral argument will help. Um, Usually that means that they think it's a clear-cut case. There you go. So Kim Ogg, this is Earl's nemesis. This is the elected official who I think she lost her last election, and I think Kim Ogg. Really, you came closer to Crow. God damn it! I thought she lost her last election, but she doesn't look anything. Here's a newer photo of her. She doesn't look anything like her Wikipedia photo. Fucking shut up! Really? Right behind me? Yeah? Cock. So it looks like Kim Ogg was until it. Get out of here. Until December 31st of what year? Oh, she's until the end of this year. Until the end of this year. Again, that's a great picture of her from like 2017. All right. So now that little and again, just remember this is going to be long. This is going to be boring. So do what you have to do. Have a beer, have two. They're small. All right. So statement regarding oral argument. He doesn't want one. Identification of the parties. Don't need it. Table of contents. Don't need it. Table of authorities. Don't need it. Statement of the case. Interesting. So they don't need to do a statement of the case unless they disagree. Let's do Texas rules of appellate. It's 38.1 appellate procedure 38.1, I think. That's appellant. I need appellees. Appellees brief 38.2. I was close. All right. Julie, you've had some terrible sex. Terrible sex. I feel bad for you. All right. So it needs not include a statement of the case, a statement of the issues, or a statement of facts unless the appellee is dissatisfied with that portion of the appellant's brief. So they're saying that they were dissatisfied with Earl's brief on that issue. But really, I think I'm going to jump to 6. I don't think I need to read a statement of the case. It's 6 pages. Maybe I will. Statement of the case. Appellant was charged by indictment with the offenses of sexual assault on a child on July 2nd, 2019. The offense was enhanced to a first-degree felony. The appellant pleaded not guilty to the offense. The jury found him guilty. On December 15th, 2022, the appellant was sentenced to 20 years in prison. The The appellant was sentenced according to an agreed recommendation in return for the state abandoning the enhancement allegation. On January 17th, 2023, appellant filed a motion for a new trial. So just so you can, Jesus Christ, Julie, just so you can see how long it's been, the motion for a new trial was a year and 3 months ago. He was sentenced in December of 2022. So, what is that old saying? Justice delayed is justice denied. On February 2022, or February 22nd, 2023, the trial court denied the motion for a new trial. The trial court certified that appellant had the right to appeal. On February 22nd, 2023, the appellant filed a notice of appeal. Interesting. So there was no written order denying the motion for a new trial. Interesting. All right, statement of facts. Appellant is BW's father. After a period of the family being separated, BW's family moved into a trailer with her family in 1996. Eventually, she got her own room and her own bed. The appellant began inappropriately making comments and touching her legs while she was learning to drive. Here's a problem. Here's a problem. So they're stating the facts that they think are relevant. So she got her own room and her own bed. One would expect the next fact to be applying to her own room and her own bed. Where does inappropriately making comments apply to her own room and own bed? Where, did she learn how to drive in her own room and her own bed? Eventually, the appellant began going into BW's room while she was sleeping, and he began penetrating her with his finger. Okay, that would imply own room, own bed. Why did we, this is the first time I've read this. Why did we bury the lead? Why don't you lead with the digital penetration and then say, oh yeah, and by the way, he was also making inappropriate comments and touching her legs while she was driving? Wouldn't that, to me, that just seems like, it makes me question. Again, I'm not trying to be like, I am always critical of briefs. Whoever's writing it, I always am critical of the briefs. So I'm not trying to be critical on this in favor of Earl. I'm just wondering, it just doesn't make sense to me why they lead. The only thing I could think of is that it was more developed factually, that it was corroborated factually, that it wasn't just an allegation made by a witness on the stand. The inappropriate comments and the touching the legs, and that it was less corroborated that the sleeping penetration. That's my guess. One occasion, the appellant told his daughter that she could date another man if she agreed to give the appellant her virginity. This angered BW, and she threatened the appellant with a knife. And again, so again, I would think like digitally penetrated would be like the top, demanded the virginity, touching the legs while driving, and then inappropriate comments, but at least say what they are. I wouldn't say it's so. There's a difference between a fact and a conclusion. A conclusion is that he made inappropriate comments. A fact is that he said, I think your butt looks nice in those jeans. One is a fact. The other one is a conclusion. The fact is he said the thing. The conclusion is that thing that he said was inappropriate. First you heard of a knife? I remember it's contested. I believe it's contested, if I remember correctly. Uh, BW said that there was a knife, said that she pulled a knife. And I believe that she's the only person who said that there was a knife. I believe that testimony is not corroborated, but I could be wrong on that. After the altercation, BW went to live with her grandmother. She returned to the family home after the appellant had moved away. Summary of the argument. The trial court did not err by allowing testimony that the appellant had engaged in inappropriate sexual conduct against his other daughter around the same time as the abuse at issue in this case. So that'd be like propensity evidence. And if it's this close, like if, but, but it does make you wonder why again they would charge, like, why would you charge for one daughter and not for the others? You know what I'm saying? It's kind of weird. The conduct rebutted the appellant's claim of fabrication, went to the relevant issue in the case, credibility. Conduct rebutted the appellant's claim of fabrication. Okay. The defense counsel was not ineffective in questioning the credibility of the victim. That opened the door to the allegations of abuse against his other daughter. However, the defense counsel had little choice but to question her credibility. Thus, the defense counsel did not render ineffective assistance of counsel just because his only viable defense came with this risk. I thought, hold on a second. Here's the amended brief. I thought that the error was not that he questioned the credibility, but that he did it in opening arguments. Am I mistaken? Am I mistaken? Because obviously he's gonna question the credibility of the witnesses. There was a pretrial hearing held on February 9th. So this is from Earl's brief. This is from Earl's brief. And apparently there was a pretrial hearing on the admissibility of the extraneous offense evidence, at which the state presented a singular alleged act that the court determined was admissible. Interesting. So notice what was missing from the state's statement of the case. The state didn't mention anything about that pretrial hearing. Well, that's goofy and weird, isn't it? They're not guilty plea, 3-day trial verdict, 20-year sentence, motion for new trial, presented motion. So there's 11 points of error, 11 issues presented. Fuck. Anyway, I'm pretty sure. I thought that the issue with the credibility, my understanding of the issue of the credibility was that the defense counsel said something along the lines of, like, it's a small trailer. Uh, there's no way that there could have been these years of abuse, thousands of acts or whatever, uh, in a small trailer with no one noticing it. Vague, something vaguely along those lines, and because he did that, then the state started bringing in all these allegations of like one daughter being told to masturbate with a Coke bottle, allegedly in front of Earl and his wife. They both were there when he allegedly told this other daughter masturbate with a Coke bottle. The daughter who peed in her closet on piles of clothes. I don't remember. I don't remember a lot of the other acts, but those are the other allegations that they brought in, if I remember correctly. So, but it was the fact that he raised it in opening argument so that the state was able to bring it in their case in chief. So if he had just like challenged the credibility of each witness as they raise the thing, well, oh, so you said this happened? Yes. Well, why didn't anybody hear it? This happened 555 times in August of 1994. Yes. Well, how did nobody hear it? Did you say anything? Did you make any noise? How did no one hear it? So so he so I don't know that this, maybe I'm just going to get irritated by reading all of these because these don't appear to be in any particular order. Defense counsel was not ineffective in questioning the credibility of the victim. That opened the door to the allegations of abuse against his other daughter. However, the defense counsel had little choice but to question her credibility. Thus, the defense counsel did not render ineffective assistance of counsel just because his only viable defense came with this risk. And I'm not really certain that that's the case, because like he's the allegation is that he sexually assaulted a daughter. If he did something other than sexually assault a different daughter, how would that show that he's more likely to have sexually assaulted his daughter? Like if he sexually assault, if the other daughter was like, yeah, he totally sexually assaulted me too. He did X, Y, and Z, right? Digital penetration, what have you. He did all these things. Well, that would make it much more believable that the first daughter was sexually assaulted, right? So I'm not sure. Thus, the defense counsel did not render ineffective assistance of counsel just because its only viable defense came with this risk. Well, again, I think the issue is that that it was made in the opening statement. I could be wrong on that. We'll find out. The appellant did not preserve his claim that the detective at trial should not have commented on whether he found the victim credible when she was speaking to him. Oh, I thought he did. Hold on a second. I thought he did. Well, at least the claim was made. Opening statements. Reed testified over defense counsel's objection that he found complainant credible. Yeah, I thought. So I wonder why they're saying that he didn't preserve his claim. That's interesting. So normally, like, if someone says something and you don't object to it, if someone says, "Hey, do you think the judge looks hot in that robe?" And the person on the witness stand answers, and then after they've already answered, barring some like excuse as to why you didn't object in time, generally speaking, if the judge is a real stickler, the judge is going to be like, well, denied, it's already been answered. You can't stuff the cat back in the bag at this point. It's already out. On a jury trial, you really have to be up on your objections. You got to be quick on your objections. It's freaking terrifying. We've got a jury trial coming up in November. It's terrifying. Like, I wake up in a cold sweat at night thinking about objecting in time at a jury trial. It's like you've got to be on your toes thinking, because I've seen other places where you could just say objection and judges will be like, yeah, cool, all right. But it seems like every time I've been in front of a judge on a trial where it matters, you have to actually have the legal basis for your objection ready. So if you say objection, Your Honor, the next word out of the judge's mouth is going to be, what's the legal basis? And if you don't have a legal basis ready to go, like, you're done. He's going to be like, overruled. Go ahead and answer. It's terrifying. So even if the issue is preserved, the testimony is harmless. Well, I don't know about that. Having an expert say that the victim is credible, or a percipient witness saying that someone is credible or not, may prejudice the jury. And again, remember what we're looking for. We're looking for whether or not this could have prejudiced a reasonable juror. Not whether the actual jury was prejudiced, but whether this could have prejudiced a reasonable juror. The credibility of the victim was fully explored at trial, and the jury was able to determine for itself whether she was credible when they saw her trial testimony. Well, yeah, but so say for example that the judge himself had said, you know what, I find that witness to have been credible. If the judge had said that, it's almost guaranteed that the Court of Appeals would be like, absolutely, that definitely prejudice the jury. They look up to the judge, they respect the judge and the judge's opinion. A reasonable juror is going to have his opinion swayed because the judge said that he found the witness to be credible. Well, what if a cop says it? A lot of people, maybe not in my little community, but a lot of people have a lot of respect for cops. A lot of people think that cops don't lie. A lot of people think that cops have never lied on the stand. Yeah, that's a good point, Jay, and that's what people on both sides of this didn't think about. People on both sides, Teresa and the crayon eater, they were both as morally culpable. They're both as terrible as the gadfly. I think his name's like John Gray, and the diddler, Jack Miller. They're all of those people are terrible people. All of them, every last one of them. And it's because of them that there is a non-zero chance that this could go back to trial. And that's, of course, that's assuming that all the things she testified about are true, or that she at least she believes them to be true. I mean, we don't know because she hasn't had a fair trial. So Jack just had a saying. What was his saying? You can you can diddle dogs or you can diddle kids, and it doesn't matter as long as you film the police, or something like that. Well, I cared about the victims. I've been saying that from the get go. Go back to my old ones. I said the people who are going to suffer are victims, not just Earl, victims. Anyway, the trial court did not err and deny an appellant's motion for a new trial. The appellant put forth affidavits showing that there were attempts to influence the jury by outside people, but not that there was jury misconduct. Well, you don't they don't have to show that there was jury misconduct. They have to show that a reasonable juror could have been prejudiced by it. So it's something along those lines. The trial court was also fully within its rights in simply disbelieving the affidavits. Absolutely. The trial court was fully within its rights to disbelieve the affidavits. The appellant did not preserve his claim that the trial court was improperly considering evidence of the jury deliberations in making his ruling on the motion for a new trial. That's new. So I think what the state is saying is that you have to object to the ruling in order to preserve your claim. That would be interesting. I was not aware of that. I may have learned something new today. Um, my I've never heard that. You can appeal a final ruling. I didn't know that you had to object to it. That's fucking weird. I don't understand that. Maybe they'll develop that further on. Furthermore, the trial court did not violate Texas Rule of Evidence 606. Well, let's look at Texas Rule of Evidence 606. The juror may not testify as a witness before the jurors of the trial. If a juror is called to testify, the court must give a party an opportunity to object outside the jury's presence. During an inquiry into the validity of a verdict or indictment, prohibited testimony or other evidence. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations, the effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statements on these matters. Exceptions. A juror may testify about whether an outside influence was improperly to bear on any juror or to rebut a claim that a juror was not qualified to serve. So it looks like the state's going to try to shoehorn it into probably this 2A exception. Which makes sense. The trial court did not violate Texas Rule of Evidence 606 by considering the charts and notes posted on the wall that showed how much attention that a jury put into its deliberations. There was no testimony nor hearsay statements from any juror about matters occurring within deliberations that was considered. Well, here's the problem. I think the problem is that the trial court considered evidence that was not presented at the hearing. I don't believe in anybody's motions that this evidence was presented that the trial court considered, i.e., the charts and notes, and yet the court considered the evidence. So neither side presented it. Neither side had the opportunity to object to it, and yet the court considered it. And there are some things that a court can take judicial notice of, like, where Texas is on a map, which city in Texas has the highest population. I don't know, the language that's spoken in the primary language spoken in Texas. The court can take some of those things into consideration, like as take judicial notice of them. You could take judicial notice of stuff, generally speaking, in like dictionaries or encyclopedias, things like that. Things are just common knowledge. Like Sacramento's the capital of California. You don't have to prove that. The court can just take judicial notice of it. But I don't think a court can take judicial notice of the charts and notes posted on the wall in the jury room. Well, the court may have seen it. I don't know. I doubt it. Muggy. I doubt it. The trial court's comment that the family had been, quote, dysfunctional, end quote, was not a material comment on the weight of the evidence. Well, if you're being accused, I can understand. It's a small point. But I can understand. You're Earl. You've been accused of diddling your daughter, and the court says that you have a dysfunctional family. Is it more likely or less likely that a daughter gets diddled in a functional family or a dysfunctional family? Well, I think you and I would agree as rational people that it is much more likely for a daughter to get diddled in a dysfunctional family than a functional family, because if the family was functional, nobody'd be getting diddled. Well, I mean, mommy and daddy may be diddling each other, but that's an entirely different equation. There's no inappropriate diddling in a functional family. So, by the court saying that this was a dysfunctional family, you have upped the odds, up the probability of diddling happening, inappropriate diddling happening, of Jack Miller levels of diddling happening. It was undisputed at trial that there was dysfunction in the family. Well, was it undisputed at trial that there was dysfunction in the family because the judge just went ahead and said it? This goes back to the clearly at trial, it was shown that there was dysfunction in the family. This is a clearly statement. Did the evidence persuade the jury that it was a dysfunctional family? Or did the jury rely on the statement of the judge that it was a dysfunctional family? Like, it was undisputed at trial that BW was digitally penetrated. Why was it undisputed? You know, and just because there is no, so if he's saying that no one presented evidence that this family was not dysfunctional, well, first of all, the trial wasn't about whether or not the family was dysfunctional. If the family is dysfunctional, then there's a higher probability that diddling is going on. But just because there is no, just because evidence is undisputed doesn't mean the finder of fact has to find that evidence to be credible. Let's say they call you, person who's watching this video with me as I'm making it, let's say they call you to the witness stand and they say, okay, witness, whatever your name is, like Michelle, I'll pick on you. They call Michelle to the witness stand and they say, okay, Michelle, how much do you make a year? And Michelle says $1 million. And then they go on, they ask about other things that are actually relevant to the case. Well, then at the end, I can say it's undisputed that Michelle makes $1 million a year. But did the finder of fact believe Michelle's statement? That's the question. Just because a statement is undisputed doesn't mean the finder of fact has to believe it. And no offense, Michelle, but I don't believe you make $1 million a year. As the finder of fact, I'm saying that I don't believe you. So even though it's undisputed, I'm going to say, no, you don't make $1 million a year. The appellant even used some of the family problems in his closing argument to his benefit. Oh, so after the judge says, oh, this family was dysfunctional, well, then the appellant used some of the family problems in his closing argument. Would he have done that? Would he have done that had the judge not said this was a dysfunctional family? How much influence did the judge have, not just on the jury, but maybe even on the attorneys? I know I am very sensitive to the judge. I'm very sensitive to the judge. And if I feel like a judge is losing attention, seems disinterested in a line of questioning, I shift it. Because that means the judge isn't concerned with what unless I'm getting to a point that I actually need to lay a foundation for. But there are some judges who are much more open to being persuaded by emotional arguments than others. And if I'm developing an emotional argument that doesn't really go to the core of the issue, and I see the judge losing interest or maybe becoming irritated that I'm wasting their time with that line of question, I will shift. If the judge calls me to the sidebar, or the other attorney, or both of us to the sidebar, and says, counsel, you guys are arguing over X. I need you to be focusing on Y. I'm not interested in X. I want to hear about Y. You could be goddamn sure that my mouth is going to be yippy yapping about why. If indeed, the odds are really low, Michelle. The odds are insanely low. I've already gone over this. You're one of the people who should feel bad that you came in late and didn't listen to the beginning, because I laid all this out at the beginning, Michelle. That's why I pick on you. As the comment was not about a disputed matter at trial, the judge's statement, even if it was comment on the weight of the evidence, was not a material one. Well, was it? Was it not material? I'm not entirely sure. The state did not offer getting ready for work to make $1 million this year. You go, girl. The state did not offer testimony which violated the appellant's First Amendment rights. Was there a First Amendment issue in here? Am I missing something? Was there a racial and religious animus? Okay, that's what it was. The state did not offer testimony which violated the appellant's First Amendment rights, his freedom of religion. Well, it depends on where you are. In a civil trial, not that common. In family law, much more common. At least where I practice. And I'm going to be very honest with you. Normally, it happens when the other side. I am pretty direct. I march down a path. I try to build a story, lay a timeline, and if I can do that, then I do that, and I don't fiddly fuck around with bullshit and gotchas, because I think judges, generally speaking, are smart enough they don't fall for the bullshit and gotchas. So it's usually not me who's getting called to the sidebar. Usually it's the other side who's getting called to the sidebar. They called me up, so it's not a ex parte communication. So both counsel have to come up so that the judge can say to both counsel, look, focus on X, not on Y. Thank you, Your Honor. Yes, Your Honor. The state did not offer testimony which violated the appellant's First Amendment rights. A comment he made to his own daughter that she should become a Mormon because in Mormonism, fathers can marry their daughters is relevant to show a sexual interest in his daughter and that he was grooming her. I'm going to say the state has a point there. I don't like it. I think the state at trial could have approached it differently. It's one thing if the witness says, dad said I should become a Mormon because in Mormonism fathers can marry their own daughters. That would be I think better, but I don't believe that's how it was developed. I believe that it came out in a closing statement or something like that. But it's the statement is not used for any impermissible purpose. Well, I don't know though. I don't know. There's something inherently kind of biasing about bringing religion into it. I don't know. Also, the defense counsel did not commit ineffective assistance of counsel by failing to object to testimony from the victim about the appellant's racist motivation and not wanting to have his wife's child with another man in the appellant's house. I'm going to go ahead and say that yeah, he did. Yeah, he did. Racism is a big taboo. It's a no-no. It's a naughty thing. It's not good to be. It's it is highly frowned on to be a white male who is accused of being a racist, especially I would assume in the South. I'm going to. I've never lived in Texas, but I'm going to assume that with the history of the Confederacy there, with the first slaves that were freed post Civil War, I think were there, um, with the fairly large African American populations in uh, Dallas and Houston. I'm gonna suggest to you that it would be very polarizing to be called a racist in front of a jury, in front of a mixed race jury. Well, WTT, it's fine. So my understanding is it's fine to be racist as long as you're not white, in which or advocating for whites. Because if you're a black person advocating for whites, somehow that makes you a white supremacist too. That's my understanding. Now, I'm not going to say whether that's right or wrong. I'm just saying that just because there's racism doesn't mean that it's bad. It's only bad if it's a white man who's accused of being racist against non-whites. And apparently, in this case, it was a black father. So mixed race child would be mixed black and white. So, the ultimate taboo. Well, I don't know. Is anti-Semitism now the ultimate taboo, or is being anti-black the ultimate taboo? I can't keep them. It changes too fast for me. I can't keep up with it. I just know that because I am white, I am apparently inherently racist. It's a an affliction of not having enough melanin in my skin. So, uh, but it's not racist to call me racist for being white. It's just something that's endemic to being white. It's just I'm racist, apparently, allegedly, you know, something. I digress. Uh, that would be improper. That'd be improper opinion testimony. Cranky elder god. A percipient witness is supposed to testify about what they could see, hear, taste, touch, smell, not about they think someone's a racist. So, racist is a conclusion. Racist is something that the jury should have to figure out on its own. It's not. It's not something for a witness to testify about. Now, if it's something where the witness is going to testify that, like, yeah, Jim Bob was a member of the KKK or a neo-Nazi or whatever, and that's not opinion testimony anymore. That's a statement of fact. He's a member of a organization that is inherently racist. Well, so like I would have a huge motivation for not wanting my wife to be pregnant with another man's child. I don't care. I'd be racist against whatever race my wife had that baby with. I'd be racist against all the races at once because that's my wife who would be pregnant with another man's child. And and the thing, like, and if it came out and it didn't even look like me, I mean, if it came out and it looked like me and I didn't know, okay, like I got cucked, great, right? But if it came out and it didn't look anything like me, it's like chocolate milk coming out, and I'm not chocolate. I mean, like, uh, so we're not arguing the facts about whether Earl was racist or not. I don't I don't personally believe Earl was racist. What matters is that it was brought up at trial to a mixed jury. That's what matters. The jury wasn't sitting in on Discord talking to Earl. The jury doesn't know that Earl went out. uh, auditing multiple times with the Batosai. That he apparently had a good enough relationship with the Batosai that he shared nude pictures of his girlfriends with the Batosai. The question from the state did not show that this was the testimony the state was seeking. By the time the appellant could have objected, the jury had already heard the testimony. Well, I mean, that's kind of a shitty thing to do. Like, you're supposed to know what your witnesses are going to testify about. That's the whole point of trial prep. You get them in, you talk to them. Okay, what are you going to testify about? If I ask you this, what are you going to say? If I ask you this, what are you going to say? If I ask you this, what are you going to say? Oh, I didn't know. That's some bullshit. I didn't know that they were going to testify about. And I don't remember that. I don't remember that the state wasn't looking to elicit that information from the motion for a new trial opposition. Well, see, that's why you're not an attorney. That's why you're probably clinically retarded. No offense. Um, Earl's not going to be in front of those judges. And these judges aren't you, and they deal with appeals all the time. And these judges understand that sometimes innocent men get convicted at trial. That's the whole point of a motion for a new trial. That's the whole point of a new trial. So the judge is going to see him. The judge is just going to have one brief and the motion, the opposition to the motion, the transcript from the motion hearing, the transcript from the trial. That apparently that initial motion, the February motion, February 2022 motion, couldn't he have objected on the grounds that had nothing to do with the allegations? Well, so here's the problem. Someone testifies. They say, so you say, did you have any reason to believe that Earl would have touched his daughter? Yeah, because he hated his wife because she was carrying a mixed race baby and Earl's racist. Then what are you gonna do? Object? Objection, Your Honor. That's irrelevant. Move to strike. Goes beyond the scope of the question. All more prejudicial than probative. Your Honor, objection, objection, objection. And then the court's gonna be like, oh yeah, cool. All right. So granted. Jury, pretend you didn't hear that. It's too late. Too late. Cause it's too late, baby. Now it's too late. A reasonable defense counsel would not have objected to keep from emphasizing the testimony in the jury's mind. Really? I don't know. I don't know. I mean, clearly, right? Clearly. See, I probably would have objected, but it would be more to make sure that I preserve it for trial. I would object to preserve it for trial. I would object, and then at the end, I would before the jury went back to reconsider, I would move for a new trial on the basis of all the issues that I had objected to prior to the state resting its case. And I would say that the jury has been so tainted by all of this that there's no way they can give a fair verdict. And then when the judge would deny that, then okay, fine. We go and we see what the jury does. And if the jury doesn't give me the verdict I want, then I would move for a new trial based again on those objections that I'd made previously. And Basically, it'd just be another shot for me to try to get a new trial, especially if I thought it wasn't going well. Also, a reasonable defense counsel could have thought that the testimony was background evidence about a matter which the jury was already aware. A reasonable defense attorney would be aware of all the background material to which a jury is aware. You wouldn't have to guess. You would have been sitting there paying attention, probably taking notes the entire fucking time, because that's what a reasonable defense attorney does. It sits there and pays attention when people are giving testimony, when questions are being asked, when the judge is talking, when statements are being made in court. You're fucking paying attention. Like, what a reasonable defense attorney could have thought that the testimony was background evidence about a matter which the jury was already aware. What background matter? And were they already aware? Where's your fucking citation to the record, sir and or madam? Is this a sir or madam? Who prepped this? It looks like Zachary Gibson signed it, but it looks like the state of Texas has Colson, Oxford, and Marshall. Have I told you this is going to be slow as shit? Because guess what, boys and girls? If you're listening on the podcast right now, I am furiously masturbating while I research who Simone Colson is. You can't see the screen because you're listening to the podcast, but I have my pants down, my turgid penis in my hand, and I'm stroking it quickly. It's well lubricated, glistening. A Russian page for Facebook. I don't think I want that. They have race down here? Jesus. Jesus. What? In 2019, making $22,000, $23,000 a year? Why? I wouldn't get out of bed for $23,000 a year. That is insane. Jesus, if I was making $23,000 a year in 2019, I would have started a shotgun. My God. Imagine going to law school, paying hundreds of thousands of dollars for law school, getting out and going to work for the state of Texas or Harris County and getting 23 grand a year. Like, what are you doing? No, no wonder. No fucking wonder. No wonder they're getting this kind of output. Lord have mercy. You know what? I am so sorry, Simone, Elena, and Rebecca. I'm gonna write to my state legislature, which isn't yours, and I'm going to suggest that they need to pressure Zachary Gibson. Sure, Zachary Gibson, Texas Assistant District Attorney. That's about what you expected, isn't it? That's about what you expected. Ooh, ooh, tough race against Shannon Baldwin for judge. Tough race. That's a sorry about that. Maybe if you get your briefs filed on time, Zach. Maybe if you could stop lying to the judges in the Court of Appeals about, hey, it's next on the it's top of the stack. Maybe if you did that. All right. So apparently $88,000 in 2022. Oof. The highest paying job held by Zachary Gibson was in 2017. So apparently it's gone down. Oh no. It looks like his max is 200. No. That's what they make in Washington. No. So homeboy, again, like $88,000 might sound like a lot of money, but no, no for an attorney. No for an attorney. Oh Jesus. I feel bad. I feel bad. Michelle says, yeah, even I make more than $23,000 a year. Really? Do you though? You were just saying you made $1 million a year a minute ago, and now it's over 23. I don't know. I don't know. Jesus. Feel bad. But was Merb's salary? Merb Merb made about $75,000 a year from one job. I made about $65,000 a year from another job, and then from my personal practice, you got to buy me dinner first to find out. Most of my money was from my personal practice. It has to be a good dinner, by the way. I I had one good year, one really good year where I cried when I wrote my check to the IRS. Um, it was good. The next year was bad because then I had to write the check to the IRS. But all it takes really is one good PI settlement, a good one. A reasonable defense counsel would not have objected to keep blah 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 blah, not objecting. Okay, in his final point, appellant claims to appellant claims cumulative harm from all the prior 10 points of error that he raised. You know, it's kind of weird. In his question or in his request to continue, he was talking about 12 points of error, and you know, no, it would not. It would not. Uh, Everything at Taco Bell has soybean oil in it. Everything has soybean oil in it. It's amazing. It's amazing. You ever wonder why people get the soft, flabby, big breasts from eating Taco Bell? It's because it has all that soy in it. Terrible. It's not even food. I remember Taco Bell with a nice White Claw. Would get caught dead drinking White Claw. I remember way back in my Wayback Machine, back in the 80s, Taco Bell used to be actual identifiable food, like actual food. It was real food, like real beef, real cheese. They had olives. I don't even think they have olives anymore on anything. They used to have olives, uh, real onions, real lettuce. I mean, it was all real. Like it was real stuff, and they actually had food that looked, smelled, and tasted like Mexican food. They had enchiladas, shit like that. I mean, yeah, they had they had uh they had good food, and now they don't. It's crazy. I think they have like dehydrated onions, like McDonald's, where it's not like onion; it's like from a factory where they've freeze dried it or dehydrated or something. It's not like they have an onion there that they're cutting up. And it's fine. Oh, the cumulative harm from all of the prior 10 points of error that he raised. However, as pointed out above, only the point of error complained about the detective's comment on the victim's credibility shows potential error. We have an admission, folks. We have an admission. Wow. Wow. They admitted it shows potential error. Wow. Okay. The error is unpreserved and it is also harmless. Okay. But they admitted the error. I mean, that's that helps. That helps Earl's case. They admitted there was an error. But again, the court will not be reading this. I'm reading this, but they admit that there was an error. So it raises the credibility of the claims. The error is unpreserved, is also harmless. As there is not any additional error in the case, there is no additional harm to accumulate. The first and second points of error. The appellant claims the trial court erred when it admitted evidence of extraneous sexual misconduct that the appellant committed against his other daughter who was living in the house while the alleged abuse was occurring against BW. It's the appellant's brief, pages 38 to 49. 11 pages. 11 pages. Do I want to go read those 11 pages? Why the fuck wouldn't I? Pages 38. All right. Trial court erred in admitting the extraneous offense evidence. The trial counsel did not open the door to such evidence, and if he did, the admitted extraneous offenses did not fit within the open door. Okay, so we're on Earl's brief. For those of you who can't see it on your screen, because you're furiously masturbating, we're going over Earl's brief, and then we're going to go back. We're going to get a refresher of what Earl's brief was, and then we're going to go back to the new one, back to the new one, back to the future. The trial court erred in admitting the extraneous offense evidence in violation of Texas Rules of Evidence 404B. Well, you know what? Let's inspect what we expect. Okay, so prohibited uses. Evidence of a crime, wrong, or other act is not permissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. Permitted uses, notice in criminal cases. The evidence may be admissible for other purposes, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. On a timely request by a defendant in a criminal case, prosecutor must provide reasonableness before trial that the prosecution intends to introduce such evidence other than that arising in the same transaction in its case in chief. All right, so it's prohibited to use evidence of a crime, wrong, or other act You can't use evidence of crime, wrong, or other act to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. Okay. You bring the chalupa. All right. As trial counsel's opening statement did not open the door to such evidence, and even assuming argument of the trial counsel did open the door, the admitted extraneous offenses would not fit within that open door. As discussed in the statement of facts, section C1 supra, trial counsel stated in his opening statement that 1, it was not possible in a trailer with 7 other people, 7 people. I had my porn up. I had to close it down before I showed it to you. You know, you're stuck on the wrong page. Get with the times. Get with the times, Laura. Damn it, Laura. Get with the times. Seven other people. It was not possible in a trailer with 7 other people for sexual abuse of the complainant to happen almost every night for 2 years without any other person in the house ever noticing. So we're talking about his opening statement. I remember this. 2, the story changed drastically from the original story 22 years ago. Well, that's a problem. There's a problem. And 3, there was a benefit to complainant for the original story as she was able to move to her grandmother's trailer, enabling her to see her boyfriend outside of the supervision of her parents. The original story was not an allegation of sexual assault, but alleged touching or attempted touching of the complainant's breast, and which allegedly took place when complainant was over 17, no longer a child, under Texas Penal Code, section 22.011. As such, this alleged act was extraneous to the charge offense and could not support the conviction either factually or legally. You're slicing that turd awful thin there. I mean, again, I'm going to be critical of both sides here. Again, now imagine, if you will, the kind of father, and I'm not saying that Earl did this, but imagine, if you will, the kind of father who would intentionally touch his 17-year-old daughter's breasts. Would you have any issue? Would you have any problem imagining that he would attempt digital penetration on that same daughter when she was 16? Is there, like, am I crazy here? Like, it seems like you're slicing the turd really thin, really thin. You lived in a trailer, guilty. Jay, I'm going to go ahead and say it. It has to be said. If you live in a trailer, you're probably not living your best life. Nothing good comes out of trailers. Do what you have to do. Mow lawns on the weekends. Go work at the titty bar. Do what you have to do to get out of the trailer park. Tough love, Jay. Tough love. But yeah, it does sound weird, right? A thinly sliced turd does sound weird. It sounds weird, the attempt that he's trying to make to separate this thing when it's just one turd. It sounds weird. Moving on. The trial court found that trial counsel's opening statement that focused on the credibility of complainant's story, aiming at the impossibility of 600 alleged instances of sexual assault going undetected for 2 years in a small trailer with 7 other people, opened the door to extraneous offense evidence that, number 1, complainant witnessed Warden groping, touching, and putting his hands up JS's skirt, which JS herself directly denied. Well, okay, so the jury gets to pick who they believe. They may believe JS and may believe BW, right? They get to pick who they believe. Now, just because there is a contradiction, just because it is contradicted evidence, doesn't mean that you have to believe that it's wrong. Just like uncontradicted evidence, you don't have to believe is correct, right? So, the question is then, is this complainant witnessing Warden groping, touching, and putting his hands up JS's skirt? Is that, if that was happening, would it make it more likely or less likely that he was doing the two finger shuffle on BW? And I would suggest to you, I would think it would. Now I'm kind of stuck here because his saying that the story isn't credible because of the 600 alleged assaults going undetected for 2 years in a small trailer. This appears to have been detected. So I would argue that this shouldn't be admissible because it was detected, which is the opposite of undetected. Uh, so I saw a story that there's a lab in Japan, I think it was, that has figured out how to make meat from poop, from human excrement. So complainant witnessed Warden groping, touching, putting his hands up JS's skirt. The complainant was BW. BW is the complainant. So that BW witnessed Warden doing stuff to someone else, which means it would be detected, right? Because someone detected it. She witnessed it. JS was called into a room and told how to masturbate with a Coke bottle, which was alleged to have occurred a singular time. How many times? How many times does it have to happen? How many times would that have to happen? In the direct presence of her mother and state's witness Sharon Warden. Again, that would be detected. And I'm not entirely sure if there's context to this. Maybe they'll add context later. Maybe it was like birds and bees explanation, not that, you know, boys' penises kind of look like this. You know, this is how sex works. You know, your mom and I are explaining this to you because we know that you're got a new boyfriend now and we want you to, you know, be protected or whatever. And here's how you apply a condom. Or I don't know. I I wouldn't want to have that conversation with my daughter. Thankfully, I don't have a daughter. But too much information. But anyway, I'm wondering if there's context to that. Over the several years that they lived in the trailer, Warden walked into the restroom while JS was using it on 2 or 3 occasions, immediately said, "I'm sorry," and turned around and walked out. So did JS testify to that? I don't know. I don't know, Laura. I don't know if there is some context that we're missing there. I've accidentally walked into the restroom while my wife was dropping a turd, and those were things I never wanted to do. I wouldn't call those sexual. So I don't know about this one, but because we're looking for sexual assault, and this doesn't seem like sexual assault. This seems like you walk into the restroom while someone's dropping a deuce. Wasn't JS the one who was pissing in her closet? So she had to be in there dropping fat deuces. She had to be in there laying logs, pinching loaves, chopping up logs with her turd cutter. I mean, I guess that could get some people going. Warden touched JS's leg mid thigh while she was driving, telling her when to press the pedals of the standard transmission car. Again, like if I ever if I ever had a daughter, I wouldn't want anybody to think that me touching her leg mid thigh while teaching her how to drive a standard transmission to tell her when to press the clutch. Uh, you know, I wouldn't want someone to think that was sexual. But I guess if you're on trial like they're going to take everything in as negative of a context as they can get it. But again, is this uh sexual assault? Is this and so in a small trailer, this is not in a small trailer, this is when driving. So the only one like that's even close, it's undetected, apparently, because this one would be detected by Sharon. This one would be detected by complainant. This one would not be in the trailer. And this one is the only one, but is that sexual assault? Assuming the testimony is as he says here. Walking in, oh, my daughter's dropping a fat deuce. It smells like someone blew up a Taco Bell bathroom in here. Closing the door and walking out. Uh, that wasn't a manual transmission car. That was how to ride stick. That's my point, Jimmy. That's my point. Uh, Texas law is well established that evidence of other crimes, wrongs, or acts are not admissible to prove character of a person in order to show an action in conformity therewith. Right. But are they doing it to show? Are they doing it to show that it is possible for 600 alleged instances of sexual assault to go undetected for 2 years in a small trailer with 7 other people? Such evidence can be admissible for other purposes, however, including to rebut a defensive theory brought about in opening statements, but that extraneous conduct must at least be similar to the allegations of the charged offense. Moses versus State. Okay. Hold on. 626. I don't see what I don't see what they're talking about. The the extraneous conduct must be at least similar to the allegations of the charged offense. I don't know that that actually supports what he's trying to say there. Maybe I'm just misreading it, and it's something that they just understand in Texas law. I mean, that's always a thing. There have been multiple occasions where I've read something and I don't get out of it what they get out of it, and you got to kind of know the way that other cases have applied it. Again, this doesn't say anything about it has to be at least similar. Let's try Wheeler. 887 footnote 22. 887. Here we go. Finally, the extraneous misconduct must be at least similar to the charge one in instances in which the frame of motive does not apply. Okay. Maybe I was just misreading the others. And I'm going to skip all these because he's verified it to the point where I'm satisfied with it. The accused may not be tried for a collateral crime or for being a criminal generally. And extraneous offenses are inherently prejudicial and raise the possibility that the defendant will be convicted for his propensity to commit crimes rather than the specified conduct which is charged by the state. To determine the proper scope of the rebuttal evidence, it is critical to first identify what specifically is being rebutted. Trial court's assertion that complainants see a citation here would have been great. Sorry, what's going on here? Laughing. I'm an AI bot. Drinking constantly under the table. Hell yeah, brother. That's what you can only see one hand at a time. But it would be great to have it'd be great to have a citation there. So he makes the unsupported allegation that to determine the proper scope of the rebuttal evidence, it is critical to first identify what specifically is being rebutted. Trial counsel's assertion the complainant's story lacked credibility based on the impossible likelihood that someone could be sexually assaulted hundreds of times over 2 years in a small trailer with 7 other people without any of those people ever seeing anything, no witnesses, no detection, no observations, no suspicions. The state's offered extraneous rebuttal evidence did nothing to rebut trial counsel's opening statement and were not sufficiently similar to the allegations of the charged sexual assault offense to warrant the admission of those extraneous allegations into evidence. Did I say that? I'm not sure that I have pants on. I could be wrong. Rather, the offered extraneous bad acts were nothing more than propensity bad act evidence. In fact, 2 of these prejudicial extraneous bad acts, supported by trial's counsel argument, as those acts were alleged to have taken place out in the open in front of other people at the trailer, which is exactly what defense counsel said would be expected for incidents in a small trailer with 7 witnesses around, that someone would have seen something. In essence, such evidence was not rebuttal at all. It supported defense counsel's contention, but still constituted harmful propensity evidence. If you want to crotch grab Laura, you're going to have to go to Josh. Thank you, Julie. I'm going to get something to drink. I won't leave you with nothing to listen to. We are going to give you a little bit of music.
Es war einmal in einem kleinen Städtchen, da lebte ein Mädchen namens Barbara. Und diese Barbara war im ganzen Land für ihren abartig guten Rhabarberkuchen bekannt. Ja, man konnte sagen, dass Barbaras Rhabarberkuchen ohne Wenn und Aber gar eine geradezu magische Erfahrung war. Abracadabra. Ja, dieser Kuchen war geradezu bombastisch. Und die Nachfrage danach erstarkte drastisch. Barbara eröffnete noch im selben Jahr eine Bar und nannte sie Barbaras Rhabarberbar. In der Stadt gab es auch ein paar Barbaren, die hatten von Barbaras Rhabarberbar erfahren. Und da sie fortan jeden Tag bei Barbara waren, nannte man sie bald die Rhabarberbarbaren. In den Folgejahren ließen die Barbaren nach und nach ihr barbarisches Gebaren fahren. Sie waren, behauptete Barbara, fast noch sympathischer als Barbarpapa. Aber die Barbaren waren stark behaart und hatten alle einen struppigen Barbarenbart. Ja, nicht apart. Daraufhin schickte Barbara ihre Barbarenfreunde zum Barbarenbartbarbier. Der frisierte den Barbaren sogar den ganzen Kopf in seinem Barbarenbarbarbier Barbershop. Er war zwar ein fürchterlicher Laberkopf, aber der Bart war danach total tipptopp. Darauf luden die Barbaren ihren Bartbarbier fein nach getaner Arbeit noch in die Rhabarberbar ein. Da tranken sie dann gemeinsam an der Bar noch ein Bier, die Rhabarberbarbaren und der Bartbarbier. Und aßen dazu bar jeder Barbarei ein Stück Rhabarberkuchen. Ich glaube, es waren 2. Ja, da wurden sogar ganz harte Männer nahbar. Und das alles dank Barbaras Rhabarber. 3 Barbaren und der Bartbarbier saßen eines Abends an der Bar bei einem Bier. Da kam die Polizei, ja, wo wart denn ihr? 3 Barbaren und der Bartbarbier.
Couple of pretty flowers is what I brought to you. I saw you through a broken window, a different point of view, and you had signs of depression from a long line of sin in your face. Tells a story about the places you have been. I love you so.
Well, goodbye, GMK. I would say I'd miss you, but, well. All right. Apologize about that. Got a beer. All right. So, with respect to complainant's alleged observations of Ward with JS, which JS herself directly denied, the purported groping and touching under JS's skirt is alleged to have taken place openly in front of other people, not repeated surreptitious sneaking through the house and into her bedroom in the middle of the night to engage in sexual conduct. That is, they are different things, yes. Was is past tense, Vlad. You are no longer listening to it. The same is true with JS's Coke bottle allegation. This was alleged to have taken place a singular time in front of another person who notably did not give any testimony to support the allegation. Again, doesn't mean it's not true. Hi, buddy. Go watch the blonde chick sing. I don't think she's blonde, though. I think she's brunette. But anyway, I love that song of hers. It's a great song. Not as good as the Germans, but the same is true, yada yada. JS's allegation the warden walked into the restroom while JS was using the bathroom on 2 or 3 occasions and immediately said, "I'm sorry," turned around and walked out, also fails to contain sufficient similarity to the charged offense and is mere propensity evidence. I would suggest yes. There was no evidence to support or suggest that this was intentional or sneaking around conduct that was aimed at being sexually assaultive conduct. I'm aware, WTT. You know, even in California, we listen to country music from time to time, and I kind of know a thing or two about a thing or two. Thank you, sir. Why don't you go mansplain it somewhere else? Finally, JS's allegation that Warden touched the middle of her thigh while teaching her drive is also insufficiently similar to the allegations of the charged conduct, no nexus connection, or similarity to the sexual assault allegations made by complainant. Harm. The admission of these extraneous bad acts harmed Warden, affecting his substantial rights and having a substantial and injurious effect or influence in determining the jury's verdict. Well, did it? Explain how. In assessing the likelihood of the jury's decision, the jury's decision was adversely affected by the error, the appellate court considers the entire record, including testimony, physical evidence, jury instructions, the state and defense theories, closing arguments, and important factors include the nature of the evidence supporting the verdict, the character of the alleged error, and how it may be considered in connection with the other evidence in the case, and also whether the state emphasized the error and whether there is other overwhelming evidence of guilt present. See, schmutz. Schmutz v. state. Schmutz. Oi, the schmutz. And we were looking at 39 on schmutz. I got the schmutz on me. 37, 38. Everything a record. Testimony important. Okay. Indeed. Mm-hmm. So okay. Just to see, that was 2014. These roller out in Ethereum. An analysis of these factors illustrates the introduction of the extraneous offenses harmed Worden's substantial rights. It's schmutz. It was schmutz. There's no physical evidence. There was no physical evidence to support complainant's nearly 25-year-old accusation. Yeah. I mean, that's weak sauce, and that's what you're leading with. Detective Reed could find no supporting records to corroborate complainant's allegations. No police reports, no CPS reports, no forensic interviews, no medical records, no therapy records from the therapist she claimed to have visited and who would have a duty to report such abuse, and no group support records from the group she claimed to have attended. That is a little stronger, I should say. Well, this is your boy. This is what your boy is saying, that there was no physical evidence. That's what he led with. I think it's a lot stronger to say that there was no supporting records. There's no contemporaneous evidence that she was abused. No contemporaneous evidence. So one thing, like, it's hearsay, right? If you make a police report, if you call the police and you say I was just robbed, and they say, like, who was it, right? And you're like, oh, it was WTT. WTT just robbed me at gunpoint. Well, that might be used to show that at the time, like, let's say that it doesn't go to court until 25 years from now. That might be useful, not as necessarily for the truth of the matter asserted, but to show a contemporaneous report was made. So when you say, oh, well, you don't have any physical evidence that I robbed you, right? 25 years ago, all that physical evidence is gone. I could say, well, but look, I did a police report at the time. I called the police right after the robbery. Here's the police report. Here's the police report number. Here's what I said 25 years ago. And my statement today is substantially identical to my statement back then. And that does have some evidentiary value. And it is concerning. It is concerning that if she did go to see a therapist, let's just assume that she was in fact abused sexually by Worden. Let's assume that. Why didn't her therapist? I mean, her therapist effed up. If a minor goes to you and says, "I was abused by my dad," you have the therapist has a duty, an obligation under law to report it. They're a mandated reporter. It's concerning. It is concerning. The testimony reflects the complainant's story was also inconsistent and contradicted by nearly every witness, including state's witnesses. Okay. Detective Reed confirmed the complainant told him sexual abuse began when she was 14, when she would have shared a room with her sister JS and occurred nightly. Detective Reed also confirmed, backed by his recorded interviews with the complainant, that he never told complainant anything about the statute of limitations changing, despite her claim that he informed her there had been a change. So this does go to the credibility of the witness. However, well, we do have to analyze it. So I think the court's going to give a lot of deference to the finders of fact. I don't know. Detective Reed and Sharon Warden, her mother, also confirmed that complainant never said a single thing about the alleged sexual assault to any family member until Detective Reed's investigation began, contradicting complainant's claims she told her family about this back in the late 1990s. Ultimately, the testimony reveals the complainant gave contradicted and inconsistent testimony where the sexual assaults occurred, when they occurred, who she told, when she told people, what people told her, and what the reactions of licensed professional, and that the reactions of licensed professional upon telling them of the abuse was that they ignored their legal obligation to make a report. That was a horribly worded end to that sentence. The testimony also reflects the complainant's story changed regarding the frequency of the alleged sexual assaults. That originally it was virtually every night when she talked to Detective Reed, but had whittled down to 3 times per week when complainant was confronted with the absurdity of her allegation that she was sexually assaulted 600 times in a small trailer with 7 other people present, but no one ever saw or heard or saw a thing. Complainant's story was similarly refuted by the testimony of defense witnesses, yada, 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 who are familiar with complainant's reputation for credibility, were aware she had denied that Warden had ever sexually assaulted her, and were aware that the layout of the house did not support complainant's contention that Warden snuck into her room virtually every night for 2 years. DW slept on the couch, was a light sleeper, and could see directly into the lit hallway. I knew someone was sleeping on the couch, and I think that's David Jr. The state's theories and arguments rested heavily on the alleged extraneous acts, and the state relied upon them heavily in its trial, evidentiary presentation, and closing arguments, discussing complainant's alleged observations of Warden with JS, that again, JS herself denied, the Coke bottle masturbation allegation, the allegations that Warden walked into the bathroom while JS was using it, which made her afraid to use the bathroom, so she started peeing on a pile of clothes in her closet, the allegation that he touched her leg while she was driving. And just to further kind of tap the nail into the coffin, in my comments, the number of people who justify their unwillingness to maintain an open mind about Earl as being predicated on the statements that were made by Earl's other daughters. That it's not just one daughter making the allegation, it's multiple daughters making the allegation. Well, when you get to trial, under penalty of motherfucking perjury, you've got one other daughter testifying, JS. So we went from 3 daughters to 2 daughters. And one of the 2 daughters didn't allege any sexual misconduct. I mean, the Coke bottle masturbation allegation is arguably, but again, if that was, as reported, done in the presence of mother, then, but anyway, but my point is that a lot of people justify it. A lot of people say, I believe the victims, plural. But here we're seeing that there is only one real victim, only one daughter alleged digital penetration. The other one denied even hands up skirt. The only physical touching that is alleged is the mid thigh while she's learning how to drive stick. And I'm not trying to say it's cool to, teach your daughter how to masturbate using a Coke bottle. I'm not saying that's cool at all. I'm not justifying any of these actions. I'm just saying that people tend to believe lots of people if lots of people make allegations. Who's the Jello Pop guy? Puddin' Pop. He had a lot of accusers. None of them were really credible, but a lot of accusers. And I honestly don't I think that Puddin' Pop guy was probably innocent. I don't think he raped anybody. Bill Cosby, thank you. But he had a lot of accusers. Trump has a lot of accusers. Just because you have a lot of accusers, people will believe the accusations. It's that if you repeat a lie often enough, people will start believing it. If you have enough accusers, people will start thinking, well, there's smoke, there's fire. Maybe one person's lying, but are 20 people lying? Well, yeah, 20 people can lie. That's why our legal system doesn't allow for that. Harvey Weinstein's conviction was just overturned. Yeah, I wouldn't doubt it. I mean, if you think people weren't knowingly and willingly sleeping with him to get an edge up, I will bet you that he didn't have to rape anybody or sexually assault anybody. Hey, you want to roll in a movie? Slurp the D. Gut, 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 gut. Here's our next movie star. My dogs are on the other side of the fence. I'll be back. Do you guys want music? You guys want music? I'll give you the better one.
Es war einmal in einem kleinen Städtchen, da lebte ein Mädchen namens Barbara. Und diese Barbara war im ganzen Land für ihren abartig guten Rhabarberkuchen bekannt. Ja, man konnte sagen, dass Barbaras Rhabarberkuchen ohne Wenn und Aber gar eine geradezu magische Erfahrung war. Abracadabra. Ja, dieser Kuchen war geradezu bombastisch. Und die Nachfrage danach erstarkte drastisch. Barbara eröffnete noch im selben Jahr eine Bar und nannte sie Barbaras Rhabarberbar. In der Stadt gab es auch ein paar Barbaren, die hatten von Barbaras Rhabarberbar erfahren. Und da sie fortan jeden Tag bei Barbara waren, nannte man sie bald die Rhabarberbarbaren. In den Folgejahren ließen die Barbaren nach und nach ihr barbarisches Gebaren fahren. Sie waren, behauptete Barbara, fast noch sympathischer als Papa. Aber die Barbaren waren stark behaart und hatten alle einen struppigen Barbarenbart. Gar nicht apart. Daraufhin schickte Barbara ihre Barbarenfreunde zum Barbarenbartbarbier. Der frisierte den Barbaren sogar den ganzen Kopf in seinem Barbarenbartbarbier. Barbershop, er war zwar ein fürchterlicher Laberkopf, aber der Bart war danach total tipptopp. Darauf luden die Barbaren ihren Bartbarbier fein nach getaner Arbeit noch in die Rhabarberbar ein. Da tranken sie dann gemeinsam an der Bar noch ein Bier, die Rhabarbarbaren und der Bartbarbier. Und aßen dazu bar jeder Barbarei ein Stück Rhabarberkuchen. Ich glaube, es waren 2. Ja, da wurden sogar ganz harte Männer nahbar. Und das alles dank Barbaras Rhabarber. 3 Barbar.
All right. The dogs sometimes get out when when someone goes out the front gate, it takes a while to close. So they were stuck on the other side of the fence. All right. Okay. So the jury instructions further exacerbate the adverse effects of the alleged extraneous bad acts, saying the jury can consider those acts for purpose of determining complainant's credibility by rebutting a claim of fabrication or lack of opportunity, even where 2 of these alleged extraneous bad acts were said to have occurred in front of other people. Oh no, sir. It's better if you do read the subtitles. It's a really great song. I've been binge listening to it for the last couple days. Finally, it should be noted that the harms of the improper admission of Detective Reed's credibility opinion. What pages were we supposed to go through? 49. The improper racial and religious animus presentations. The trial court's improper commentary should be weighed in conjunction with assessing the harm. And that was back to Schmutz. Remember Schmutz versus State? The likelihood of the jury's decision was affected by the error. The appellate court considers everything in the record. This includes testimony, physical evidence, jury instructions, the state's theories, and any defensive theories, closing arguments, and voir dire, if applicable. Important errors include the nature of the evidence supporting the verdict, the character of the alleged error, and how it might be considered in connection with other evidence in the case, which may include whether the state emphasized the error and whether overwhelming evidence of guilt was present. Warden requests this court find the trial court harmed Warden and improperly admitted the alleged extraneous bad acts, that the door was not open to those acts, they did not fit in within the open door. Warden requests this court grant relief on this claim, find that his substantial rights were violated, and grant him any and all further relief to which he may be entitled, including vacating his conviction and remanding for a new trial. I'm supposed to go to 49. This said 49. 38 to 49. Why am I going 38 to 49? Oh, he's replying to first and second points of error. Okay. Trial court erred in admitting the extraneous offense evidence in violation of Texas Rules of Evidence 403. Let's do Texas Rules of Evidence 403. Remember that 404 was propensity evidence. Yes, so the defense just said basically go read their arguments instead of like what I like to see. I didn't see any page limit in the Texas Rules of Appellate Procedure. What I like to see is they said this, our response is this. They said this, our response is this. They said this, our response is this. It makes for an insanely long brief, but you don't end up having to remember shit back and forth and shuffling papers, etc. etc. So we've already looked at the prohibited use of propensity evidence, and now we're going to look at this is prejudice. So the court, are you seeing it? You're not seeing it because this is in the way. The court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Well, I'm sure that, they only had like a year to draft this response. That's since November, I think. Didn't they? The amended brief was filed in November. The original brief was filed in August of 2023. The amended brief was only amended to change the naming scheme. So instead of naming BW, they replaced it with her initials. Woo! Thank God they amended it. So in theory, they could have started working on it as early as August 8th or August 28th of 2023. On 22K, it doesn't matter how many hours they're putting in too many. 22K. Jesus. Poor bastards. All right. So it's more prejudicial than probative is essentially what we're looking at. The court erred in admitting the extraneous offense evidence in violation of Texas Rules of Evidence 403, as the probative value of the evidence was substantially outweighed by the danger of unfair prejudice, more prejudicial than probative. Generally, Rule 403 favors the admission of relevant evidence and carries a presumption that relevant evidence will be more probative than prejudicial. When considering a Rule 403 objection, the courts must balance 1, the inherent probative force of the proffered item of evidence, along with 2, the proponent's need for that evidence, against 3, any tendency of the evidence to suggest a decision on an improper basis, 4, any evidence or any tendency of the evidence to confuse or distract the jury from the main issues, 5, any tendency of the evidence to be given undue weight by a jury that has not been equipped to evaluate the probative force of the evidence, and 6, the likelihood that presentation of the evidence will consume an inordinate amount of time or merely repeat evidence already admitted. Well, if they live next to a Whataburger, that toilet paper might be worth more than its weight in gold. In practice, These factors may blend together. And I'm looking for 319. All right, so basically all that's verbatim out of Newton v. State. Trial courts have broad discretion in conducting a Rule 403 balancing test, and reviewing courts will not lightly disturb the trial court's decision. Rather, it is only where there exists a clear disparity between the degree of prejudice of the proffered evidence and its probative value that the evidence is considered unfairly prejudicial and in violation of Rule 403. I'm just trying to annoy you, GD, and it's working. See, I baited you into commenting. You lose. Weight-wise? Hell yeah, brother. I look like I'm pregnant. Is it? An application of the pertinent factors in this case warrants reversal as there is a clear disparity between the degree of prejudice and the probative value of the extraneous evidence. First, the probative value of the extraneous evidence was to be for this motherfucker said was to be for. Was to be for. You couldn't have rewritten that so it wasn't was to be for. Was to be for. Was to be for. Was to be for. I certainly do not. And eating burritos. Hell yeah. Was to be for rebutting the assertions made in defense counsel's opening statement. The complainant's story was not credible because it was an allegation that seemed impossible to have been sexually assaulted every night for 2 years in a small trailer with 7 other people, and no one saw or heard anything. As discussed in Section 1 Supra, the presented extraneous evidence did nothing to further that rebutting trial counsel's claim, but rather were merely propensity evidence. What about defense counsel's impossibility and this lack of credibility claim is rebutted by extraneous allegations that were alleged to have occurred openly in front of others? Why are you asking questions? Why are you asking questions of the court? Why are you starting off your next sentence with or? And then the next sentence with or? Who wrote this? Did Springer's attorney write this? Jesus. Ladies, gentlemen, children of all ages? Not children. Not children. Strike that. Strike that. Not children. No, not children. Well, so unproven allegation. So Tom, the way it works is testimony in court is testimony. It is in itself evidence. And just because there's nothing physical to back that up doesn't mean that it's unproven, because the assertion made in court under oath is proof. I mean, the finder of fact can find that it was sufficient proof to rule in favor. So yeah. So basically they're asking what part of defense counsel's claim was rebutted by this evidence. They should have just said nothing about defense counsel's claim in the opening statement was rebutted by these extraneous allegations. or evidence that in 3 or 4 years a person walked inside a restroom 2 or 3 times and then immediately turned around and walked out and said, "I'm sorry." Or touching of a person's leg mid-thigh with no allegation of sexual misconduct ever being alleged by that person. Well, so didn't she allege the Coke bottle thing? Are we? Oh, we're just not going to talk about the Coke bottle thing. We're just not going to talk about the Coke bottle thing. The propensity value of the extraneous evidence was 0, and if not 0, it was marginal. The evidence did not bolster a complainant's credibility or refute an impossibility argument. Rather, it merely diminished Warden. Oh yeah, they dismissed the Coke bottle one because it was openly in front of others. The damage was huge, like my cock. No, this is not the 22K a year. This guy, I guarantee you, makes way more than 22K. Cranky Elder God, I guarantee you. This guy is the best. Was the other guy the second best criminal defense attorney in Houston? This guy is the best. The damage was huge. Again, like my cock. The Texas courts recognize the extraneous offense evidence of this nature does tend to suggest a verdict on an improper basis because of the inherently inflammatory and prejudicial nature of the crimes of a sexual nature perpetrated against children. And this is the context in which the state presented the alleged bad acts at trial and in their closing statements. Additionally, the state did not need the extraneous offense evidence in order to present the entirety of their case against Warden. Complainant's story and its inconsistencies and contradictions contain the allegations for which Warden was on trial. The extraneous offense evidence did not go to any elements of the charged offense or, as discussed above, to rebutting issues brought up by defense counsel. Instead, the extraneous matters confused and distracted the jury from the main issues at trial. An inordinate amount of time was spent on these extraneous allegations, which were presented through 2 of the state's 5 witnesses, and which comprised half of the second day of testimony before the jury, and which was a focus of a significant amount of the state's closing arguments. Finally, as discussed in Section 1, Harm section, and incorporated herein, Warren was harmed by the introduction of the testimony, which had a substantial and injurious effect or influence in determining the jury's verdict, as complainant's allegations were weak, inconsistent, weak, inconsistent, and contradicted, and unsupported by any corroborating evidence. Only propensity evidence was offered in support, and other inadmissible evidentiary items presented herein. Why do we have the extra and? Weak, inconsistent, contradicted, and unsupported would just flow much smoother. Like my bowels with diarrhea. Huh. His son is the jackhammer, huh? Nice. Good marketing. Gets you to remember him and advertise him for free, right? Okay, so blah blah blah. All right, so now that we've done that, now let's go back to the state's brief. All right, so the appellant claims that the trial court erred when it admitted the evidence of extraneous sexual misconduct that the appellant committed against his other daughter who was living in the house while the alleged abuse was occurring against BW. This is not so. This additional evidence rebutted the appellant's contention that the victim had fabricated these charges against the appellant. Well, see, so that is a loose rebuttal, right? That is a loose summary, not a citation, not a quote. If we go back to what the statement was, Where was it? It's amazing how much of this I don't remember. Scroll up, scroll up, scroll up, scroll up, scroll up. During opening statements, this is what Warden's attorney is arguing was said. During opening statements, defense counsel told the jury this case would come down to credibility, and that there were three reasons why complainant's allegation was not credible. One, not possible in a trailer with 7 other people for sexual abuse to happen almost every night for 2 years without any other person in the house ever noticing. 2, story drastically changed from the original story 22 years earlier. And 3, there was a benefit to complainant for the original story, as she was able to move to her grandmother's trailer, enabling her to see her boyfriend outside the supervision of her parents. Now, the judge allowed in all this other stuff under this one, so it's not credible, but for a specific reason. It's not just that it was not credible. It was not credible because the defense's theory is it is not possible in a trailer with 7 other people for sexual abuse to happen almost every night for 2 years without any other person in the house ever noticing. So he got a free pass with one daughter, or was it just piling on accusations? I don't understand what you're saying, Tom. I'm trying to not read this as you being a dickhole. I don't think that we know at this point whether or not BW was actually molested by Earl. I don't think I can say with any certainty that I know that. But Earl hasn't gotten any free pass. There was only one complainant against him. That's why there was only one charge brought against him. The other daughters, for whatever reason, didn't think it was worthy of their time to try to bring a case against him. Good point, GMK. Good point. And if Earl ever needs to file bankruptcy, I'll send him your way. That you believe him. Yeah, I don't know. I don't know what. Sorry, Tom. You're going over my head, buddy. So he says this additional evidence rebutted appellant's contention the victim had fabricated these charges. What are these charges? These charges against appellant. It wasn't. Oh shit! It wasn't just. If all Earl's attorney had said was that complainant had fabricated these charges against appellant, then I don't think any of this other extraneous evidence would have come in. It was because it was specific. There was specific things. Trailer, 7 other people, sexual abuse every night for 2 years without anybody noticing it. It was specific. And so because it was specific, then they could show, if they showed that that sexual abuse happened in that trailer without anybody else noticing it to someone else, well, that would make it more plausible that it happened to BW. if they could show that, I don't know, something else happened every night for 2 years without any other person in the house noticing it, well, that might make it more likely. You know what I'm saying? So they need to show something that's making that specific thing more likely. So they need to respond. The extraneous stuff has to respond to that. Has to show that that theory of defense is lacking. Standard review, balancing the probative value of the evidence against its prejudicial effect. We're starting off with 403. Well, that's interesting. We're starting off with Rule 403. Remember, Rule 403 was the second one, the more prejudicial than probative. So they're going to ignore the prohibited uses, and they're going to start off with Rule 403. Okay. I don't know what that tells you. Why he's starting there, I don't know. A trial court's ruling on the admissibility of extraneous evidence is reviewed for abuse of discretion. Great. A trial court's evidentiary ruling that is within the zone of reasonable disagreement and correct under any theory of law is to be affirmed. Okay. Extraneous offense evidence is not exempt from the scope of Texas Rule of Evidence 403. Sure. Rule of Evidence 403 states the court may exclude relevant evidence if its probative value substantially outweighed by danger of unfair prejudice. Yada, yada, yada. Okay. A proper 403 analysis should consider the following 403 factors. How compellingly did we not just go through this? So unless we have some different balancing thing or a newer case, let's find out. Okay, we got De La Paz. Court of Criminal Appeals of Texas. That is the highest court in the land for criminal cases for Texas. And then this one was Newton v. State. So Newton v. State is a lower court than the Court of Criminal Appeals. This one was August 19th, 2009. This was March 2009. So why? $348. Again, for those of you who are just listening and not watching, I'm once again furiously masturbating. Inherent probative force of the proffered item of evidence. Two is the need for the evidence. Improper basis. Distracted. Undue weight by a jury. Guess this would also be undue weight by a jury. Okay, so it appears that these 6 factors are stated more succinctly in these 4 factors. The fact that you have an imagination of what that's like impresses me. Do you still have the chalupa? While it is true that evidence of a wrong or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character, why did we switch to 404? Such evidence may be admissible for other purposes, including the rebuttal of a defensive theory. Rule 404 only forbids evidence that is offered or will be used solely for the purpose of proving bad character, and hence conduct in conformity with that bad character. De La Paz, cited above somewhere, apparently. Oh, I had it open already. And you weren't seeing what I was reading anyway. At 343. Okay, so they're going to have to show that the logical and legal rationales that support its admission on a basis other than bad character. Okay, that shouldn't be an issue, right? So we're going to see where they're going to show that it goes to something other than bad character. Likewise, Rule 403 favors the admission of relevant evidence and carries a presumption that relevant evidence is more probative than prejudicial. The Court of Criminal Appeals has cautioned that the rules of evidence, especially Rule 403, should be used sparingly to exclude relevant, otherwise admissible evidence that might bear upon the credibility of either the defendant or complainant in such he said, she said cases. Rather, well, let's look at it. 562. Why not? 562. So this is dealing with cross-examination. I'm not entirely sure why they're bringing it in. So under Hammer versus State, the question was raised about like, can you just generally attack the credibility of a witness generally? And no, and great, right? So I don't know exactly that that's as on point as they may want it to be. We have discussed this, sir. Don't make me start playing shitty German music again. Don't do it. I swear to ever loving Christ. I swear to ever loving Christ, you bastard. You weren't supposed to tell anybody, Taze. Rather, Rule 403 only authorizes the court to exclude relevant evidence of its probative value if its probative value is substantially outweighed by a danger of unfair prejudice. Johnson. Well, shit. Someone should apparently call what's that douche canoe's name? Michael Eline, because they're citing an unpublished case, or as he calls it, a DPub. I'm cool. I have names for things like DPub. This DPub case, you can't cite a DPub case. And here, they're citing a depublished case in an appellate brief, and no one is laughing them out of court. Fucking weird. Quick, to the bat phone. Call Michael Eline. He's a reserve. What is he? Inactive Marine. With this framework in mind, the trial court did not abuse its discretion. Well, are we going to develop that some more? No, we're going to move on to the next one. That's a weak argument. That is a super weak argument. They laid out all the rules to kind of apply, and then they never fucking applied it. They just stated, oh yeah, by the way, court didn't abuse discretion. Hey, thanks for applying the facts to the law. Thanks for doing your goddamn job. That's goddamn rooster. I swear to Christ. I don't know how loud he is for you guys, but he is so loud when he's right next to you screaming. He's gonna do it again. He's looking at me. He's just straight staring at me. One day, straight into the pot, motherfucker. One day. All right. So that was a terrible argument. All right. So now argument number 2. The testimony of the appellant's other daughter regarding inappropriate sexual conduct towards her rebutted the appellant's claim of false accusations. It was a very, very specific claim. It was a very specific claim that it was impossible in a small trailer where 7 people lived for sexual assaults to have happened every night for 2 years without anyone else knowing it. That's a very specific claim. It's a very specific claim. At trial, the appellant, am I on the right thing? Yeah. At trial, the appellant claimed that the victim fabricated these allegations against the appellant because she wanted to date another man. Okay. The defense counsel mentioned he intended to attack the witness's credibility in his opening statement. The state is allowed to rely on that to introduce evidence rather than having to wait for a rebuttal. Inigo? Oh, no, you're Fabio. You better say just out of arm's reach. He's a beautiful bird. He's an Easter egger that we bought as a chick. Supposed to be 80% sexed. Supposed to be a hen, but sure enough, he's not a hen. It is California, so maybe I should ask him, right? Do you identify as a hen, Inigo? Or Fabio, sorry. He's a beautiful bird. 80% sex, that means it's 80% likely that they're all female, which means that for any given egg, there's a 20% chance that it's going to be a rooster. Because for laying birds, roosters don't have much value. Now, we have 2 roosters, which means all of our eggs are fertilized. Trust me, all of our eggs are fertilized. These guys go around here raping like gangbusters. So whenever we need new chicks, we just hatch them out. Hatch them out, brother. To get the flock going, yeah, we bought chicks. Our first batch, well, actually, we bought 2 batches. We bought 2 batches of chicks, and then we've got a lot. We've got like Jesus, like 50 birds. 50 birds or something like that. We've got eggs for days. Cartons are now $1.50 a carton. Can you believe that? $1.50 a carton. Insane. Does that make it 80%? Yes. Although we've gotten way better luck. I think they advertise it 80-20, but I think it's better than that because we ended up getting like probably about 30 chicks or 30 chicks total, and we only ended up with 1 out of that. Indigo was actually hatched from fertilized eggs that we bought. We bought a bunch of fertilized eggs from a friend to help us get going. We bought 2 batches of chicks from the store and 1, like a dozen or so eggs, fertilized eggs to get us going. And we only have 2 roosters, so that's pretty good, at least so far. I think one of the young batches, one of those might be a rooster, maybe more, but I think 1 crowed or did a small crow the other day. Well, so I'm not necessarily interested. I'm interested in good layers. I like lots of eggs. Trial claimed the victim fabricated these allegations against the appellant because she wanted to date another man. So, like, what does it go? What do any of those other things? What does the allegations about him touching JS have to do with anything? Oh, so she's saying that so the argument the state here is making is that JS didn't want to date another man, and yet she's still making allegations that he showed her how to masturbate with a pop bottle, that he walked in on her when she was pooping 2 or 3 times, apparently, during the several years that they lived in that trailer. that he touched her mid thigh while he was teaching her how to drive stick shift. And what was the other one? What was the fourth one? Oh, the fourth one was that complainant that BW alleged that Warden put his hands up JS's skirt, but JS denied it. He also suggested the abuse was not credible because of the layout of the small trailer. He even put his son on the stand to suggest the appellant's touching of his legs during driving was not sexual. Well, I mean, I would hope not. The appellant was entitled to make these factual defenses. However, the state was allowed to clarify that his factual assertions were not as plausible as the appellant made them seem. The appellant's other daughter was being abused by him in similar ways. Well, was she though? He would touch her inappropriately when teaching her how to drive. He touched her apparently mid-thigh? Is that inappropriate? Like if she's wearing jeans or something and he touched her mid-thigh, would like here, shift. He would frequently go into the bathroom when she was naked. We have apparently contradicting narratives here, because I got 2 or 3 times on this one. So VRR volume 6 at 19 to 21 says on 2 or 3 occasions, immediately stated, "I'm sorry," turned around and walked out. Now this one, VRVI, reporter's record, I think, is VRR. Seven to 43. I assume so. So they're citing different. So apparently they're using reporter's record volume 6, and these guys are using reporter's record volume 6 at 7 to 43. Volume 6 at 7 to 40. Here. Volume 6, VI is volume 6, 7 to 43. Volume 6, this is between 7 to 43. So what does it say? Like, what does it actually say? What is the actual testimony? Volume 6 at 19 to 21. What does it say? Does it say that he walked in there frequently when she was naked? Or did it say that he went in there 2 or 3 times while she was using the bathroom, immediately say, "I'm sorry," turn around and walk out? Which one is it, dude? Like, which one is it? But I tell you one, the Court of Appeals is going to know. And if the state is misstating it, then the Court of Appeals won't know. If Earl is and his attorney are misstating it, number one, they have nothing to gain. They have nothing to gain by misstating it, because the Court of Appeals is going to read the record, and they have lawyers who work for them. They call them law clerks, who were going to read the record and who are going to say, yes, the record actually says this, or no, it doesn't, or here's what neither side really accurately reports what the record says. Here is the verbatim language from the record, right? So it doesn't do anybody any good to lie. So I'm not sure entirely what the fuck is going on. I'll be perfectly honest with you. She became so afraid of appellant invading her privacy, she began urinating on clothes in the back of her closet rather than using her own bathroom. Like, I think that is more prejudicial than probative. Afraid of him for what? And was it logical? I mean, like, what if she had a phobia of men with lisps? What if that was her phobia? So she became so afraid of him invading her privacy, she began urinating on clothes. Did she begin showering in her closet too? I don't understand it. And how in a small trailer, for the love of God, how in a small trailer can someone piss on clothes in the back of her closet without everybody smelling piss in the trailer? You done? Yeah, you better run. Inigo's going to kick your ass if he catches you with his women. On another occasion, the appellant instructed his own daughter how to best masturbate with a Coke bottle. Well, huh. Notice that they leave out kind of important things that defense was saying. Look, the important thing here is that mom was present. That's the important thing. And here they're like, it's really bad. It's really bad. We're just going to ignore the fact that mom was present. This I don't know how to deal with, or no, yeah, that the defense wasn't making an issue out of this, so I don't even know why that's there. But I would have objected to it coming in. This somebody's lying somewhere, either the defense or the state is lying, and this, I mean, he would touch her inappropriately. Either he's touching her mid-thigh or it's inappropriately. I mean, like, how is he touching her mid-thigh that it's inappropriate? Is he like massaging her thigh? Is he saying, "Ooh, you've got some nice thighs. I'd love to have my face between them"? Like, what is he doing that's making it inappropriate? If he's in a car teaching her how to drive stick, what is inappropriate? I don't understand. The acts of abuse against appellant's other daughter, see, now they're characterized as abuse. What was the abuse? Touching her inappropriately while teaching her how to drive. You see my real problem with that is they're trying to suggest something other than what the record reflects. Instead of saying he would touch her mid-thigh when teaching her how to drive, he would touch her inappropriate. It sounds like maybe he's like tickling her cooch or something like that, tapping her taint. Yeah, tuning in Tokyo. It smells like desperation. That smells like desperation to me. So far, I haven't seen anything impressive about this. We're on page 23 out of 71. I told you it was going to be long and boring, like my cock. But where are the acts of abuse instructed? I don't know. Instructed. Instructing is an act of abuse. But again, they make it sound like you got it, buddy. The acts of abuse against the appellant's elder daughter rebut the claim that the allegations come from BW made because she wished to date another man. Okay, all right. So all of this is to say that it wasn't offered to rebut the opening statement. This was offered to rebut any proposed evidence that it was done because he was going, or that because appellant instructed, or because warden was, it was done because she was wanting to date another man. Okay, yeah. So where did Volume 5 RR so at trial, the appellant claimed that's warden. Okay. All right. At trial, so here is their argument. At trial, Earl said BW is lying. She made this up because she wanted to date another man, which leads me to my next point is it's almost always a mistake for the defendant to testify. It can not backfire. There are times when it hasn't backfired, but I just have a real hard time thinking that it's worth the risk. We've swapped out roosters. We've swapped out roosters, guys. Doing a dance for the ladies. She wasn't interested, apparently. All right. So, all right. His argument is Earl testified, and therefore they got to present evidence to rebut that testimony. And they didn't have to wait for Earl to make that testimony because defense counsel mentioned he was going to attack the witness's credibility in his opening statement. Now, how much sense does this make? So, they would have had to have known that Earl, because Earl is a defense witness. The state could not call Earl. Only the defense could call Earl to the stand. So the defense called Earl to the stand after the state had rested. So the state's case in chief had been presented, and then Earl got called to the stand. Just so that you guys know the timeline. Has to be that way. There might be a way that they could call him prior to there might be some way they could do it, but I'm not aware of any way where you could call the defense, where the prosecution can call the defense to the stand in a criminal matter. So their argument is that they knew specifically that he was going to say that she made these allegations because she wanted to date another man. And because of that, they have a right to, prior to that, bolster her credibility with this extraneous act stuff. To counter this argument, this statement that Earl hasn't made yet. It doesn't make any fucking sense to me. I'm not saying it's a loser. It doesn't make any sense to me. And because it doesn't make any sense to me, my instinct is that it's not a good argument. So they're trying to support it with, the defense counsel mentioned he was going to attack the witness's credibility in his opening statement. Well, great. But what did he say in his opening statement that opened the door for you to make these, or to elicit this testimony from your witnesses? Because generally speaking, every defense counsel is going to attempt to attack the witness's credibility for the state. And so if that is the case, then everybody everywhere would have the door open to everything like this. But we know that's not the case. We know that's not the case. There are rules of evidence in place to prevent that. So they're saying something so general like, well, defense counsel said he was going to attack the witness's credibility. So because Earl stated after our witnesses testified that this was a rationale for why she made the statements, then before he did that, we knew he would do it or something. And so we offered this evidence for the purpose of countering that testimony that we knew would come, but they didn't know it would come. Estes above. All right. Well, have we pulled up Estes before? We might have. Uh, 47 Southwest 3rd at 760. All right, share this tab instead. This is probably not a good live to catch of mine. This is going to be long and boring. It's already been long, and it's going to get even more boring. And there's random rooster noises in it and bad German hip hop. Sade also proposed to present evidence from Jackie, who was 16 years old at the time of trial, outside the jury's presence. She testified that she lives on the same street as appellant, been to his house numerous times to visit Jason. Jackie testified that on different occasions, appellant had asked her to spend the night in his room, had smacked her butt, had touched her breast while looking down her shirt, and had talked to her about piercing of sexual organs, had told her she was pretty, had put the back of his head between her legs and against her clothed body while she was sitting down. Appellant objected to the testimony from his ex-wife and from Jackie, arguing that it was inadmissible under rules of evidence 403 and 404B. Trial court overruled the objections. Appellant's ex-wife and Jackie refused or testified about these same facts to the jury. All right. So this is a child. This is another child molestation case. I assume if you pay for it, probably have to pay for it. Yeah, you got to pay for it. Yeah, and you pay in one way or another. So they brought a 16-year-old who was going to testify about other things that would indicate that he was interested in having sex with underage women. Hold on a second, I'm down there. just want to see something real quick. 2016. So this is after 2009. I just want to point out this is after 2009. And and this one uses the 6 factors that Earl's attorney had cited instead of the 4 factors that the defense cited in De La Paz. This was the De La Paz one, the 4 factors. So what that means is that the courts, despite this, the courts have settled on the 6-part test instead of the 4-part test in Texas. I don't know how or why. I don't care to learn it, but if in 2016 the Court of Appeals is using the 6-part test 7 years after the 4-part test was laid out, I'm going to guess that the 6-part test is the correct treatment. I don't know enough about Texas. I've only been there a couple times, and it was terribly unimpressive. I drove through the Amarillo part between Oklahoma and New Mexico a couple times. Nothing to see there. I flew into Houston once or twice. I drove from Houston to Austin, and then from Austin to Arkansas. Again, nothing to see. I don't know. I mean, Texas might be a great place to live. I'm not going to shit on it, but you know, I'm a California boy. I likes what I likes. I don't like our laws, our gun laws and stuff, but it's a damn fine state as far as the weather and the scenery and the mountains, the birds and the bees and the forests and the trees. All right. So here in appellant's case in chief, he presented defensive evidence with the intent to negate Katie's testimony concerning his sexual abuse. Specifically, appellant presented testimony from his wife who attempted to undermine Katie's testimony that appellant had engaged in bondage sex. Appellant's wife testified she had never known appellant to engage in any form of bondage sex, and that the leather the police found in appellant's house was not used for bondage activities. The trial court could have reasonably found that the testimony of appellant's ex-wife, which proved the appellant was interested in, had participated in bondage sex, rebutted the inference intended by the appellant's wife's testimony, which was that Katie must have been fabricating a claim of bondage-related sex. Oh, hey, look, someone better get fucking, his name isn't Einhorn. What is his name? Not Einhorn. Eiler? Another one. They're citing not designated for publication. So there was a defensive proffer already made. The record belies. See, here's what I'm telling you about. Like, it doesn't help you to lie about what the record says. The record belies appellant's argument that it was actually the state who elicited the evidence about bondage. At one point, appellant's counsel asked appellant's wife, "Are or were either of you or appellant into any form of bondage?" She said no. Later, the following exchange occurred. Defense counsel: you married many years to appellant. Is that correct? Yes, 11 years. And you've never known him to engage in any form of bondage sex. Is that correct? No. I mean, that's correct. That's correct. Yes. Similar, although appellant's development of testimony from Reeves and AS, he attempted to characterize Katie's testimony as unreasonable and unlikely by presenting evidence that he generally acted appropriately around underage girls. Jackie's testimony about appellant's sexually inappropriate acts toward her rebutted this evidence. So here's a question, if anybody knows, did the state call JS and BW as rebuttal witnesses? Was their testimony presented as rebuttal testimony to Earl's statements about? That would be interesting. It'll be interesting to know the context. If they were elicited in the case in chief by the oh, you're not seeing any, you weren't seeing any of that. God damn it. So it would be interesting. It'd be interesting if because in Estes, it was Jackie was a rebuttal witness. Ooh, another citation to a unpublished case. Eline, thank you. Not Einhorn. Einhorn. That's God, what's the name of that movie? Pet Detective. Einhorn is the kicker. Here, the testimony from complainant and 3 other women who alleged they were abused by appellant is relevant to rebut appellant's defensive theory that complainant invented or imagined her allegations against appellant. Third point of error. The appellant then alleges that if the defense counsel's trial strategy opened the door to evidence of the appellant's abuse against his other daughter, then he committed ineffective assistance of counsel. I don't know. You tell me. I'm just a first-year family law attorney, so he's probably better than me. How about that? The appellant then alleges that if defense counsel, blah, 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 then he committed, defense opened the door, but the defense counsel had a little choice. He did not commit ineffective assistance of counsel. Okay, I assume we're going to develop that. In order to prevail on a claim of ineffective assistance of counsel, the appellant must satisfy a two-pronged test, which requires showing that 1, counsel's performance was deficient, and 2, counsel's deficient performance prejudiced the defense, resulting in an unreliable or fundamentally unfair outcome. It is terribly hard to win on ineffective assistance of counsel. It is probably the hardest one of the bunch for Earl to win on. Almost impossible to win. The appellant must show there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine the confidence in the outcome. Under Texas law, the appellant has a burden of proving ineffective assistance of counsel by a preponderance of the evidence. A fair assessment of the attorney performance requires that every effort be made to eliminate the distorting effects of hindsight, to reconstruct the circumstances of counsel's challenged conduct, and to evaluate the conduct from counsel's perspective at that time. A reviewing court must indulge a strong presumption that counsel's conduct falls within a wide range of reasonable professional assistance. That is, the defendants must overcome the presumption that, under the circumstances, the challenge action might be considered sound trial strategy. And yeah, I mean, that's a tough one. I think it is an excellent argument to make, and one that I would not foresee opening the door. So I think what Earl's argument was that the what's the point of arguing it? Because there's a chance. Duh. So I think Earl's attorney's position is that the court erred in allowing that extraneous act evidence. In the alternative, if the court didn't err in doing that, then the attorney should have known that that shit was coming in, and so the attorney erred in opening the door for it. I don't think the attorney erred, but what I mean, the attorney wrote a affidavit or a declaration that he attached or he gave to the new attorney saying that he made a mistake. But I think he made a mistake on like the closing argument stuff, like not objecting to shit in the closing arguments. That I think is more likely attorney error. But it's also far less prejudicial than allowing all that evidence would be in. So the beginning stuff, much less likely to be attorney error, much more harmful. The end stuff, much more likely to be attorney error, much less harmful. So it's just a harder argument to win too. The Strickland inquiry is an objective inquiry that asks what a reasonably competent attorney would do, not what the attorney actually thought. Strickland calls for an inquiry into the objective reasonableness of counsel's performance, not counsel's subjective state of mind. The Strickland test is an objective one. As long as counsel performed as a competent lawyer would, his or her detailed subjective reasoning is beside the point. You'll notice that there are citations to like First Circuit federal U.S. court cases or U.S. Supreme Court case, and Strickland itself is U.S. Supreme Court case. The reason why is because, GD, shut the fuck up, dude. I told you it'd be long. Like my dick in your ass. The reason why is because this is a Sixth Amendment issue. And the United States Supreme Court has made determinations about the Sixth Amendment. And so it is the controlling court. A reviewing court must look to the totality of the representation when reviewing these claims, and its decision must be based on the facts of the particular case. A silent record that provides no explanation for counsel's actions usually will not overcome the strong presumption of unreasonable assistance. No, you're not, dude. You've been sitting in here jerking off, looking at me, thinking about how pretty I am, thinking about how you want to feel my beard nuzzled against your neck, you faggot. Thinking about my cock sliding between your cheeks. Homo. Why are you thinking about stuff like that? Thinking about the taste of my jizz in your mouth? Man, why are you even thinking about that? GD. You're gross, dude. Grow up. Stop thinking all homosexual. To warrant reversal without affording counsel an opportunity to explain his action, the challenge action must be so outrageous that no competent attorney would have engaged in it. In situations where trial counsel has not been afforded an opportunity to explain his actions, usually an appellate court will summarily reject the complaint. Hell yeah, you heard it here first. GD! Make you my what do they call that? What's that organ meat? What's that organ meat? What? Ain't nothing wrong with a little gay love. Isn't that right, GD? Not Haagen-Dazs or Hassenpfeffer. Ugh. The organ meat. Come on, GD. What's it called? What's it called? What's it called? You're not helping, GD. I'll Google it. Scottish haggis. That's what it is. Haggis. Anyway, the joke would have been, I'll put my organ meat in your stomach, and I'll make you my little Scottish haggis. No, it would have been good if I could have remembered haggis. But I've had a beer now, and yeah, because I'm an alcoholic. I've had a beer over a 3-hour live stream, 3 hour and 11 minutes and 44 seconds. In situations where trial counsel has not been afforded an opportunity to explain his actions, usually an appellate court will summarily reject the complaint. I do believe, however, that trial counsel submitted an affidavit. So, yeah, trial counsel should ordinarily be afforded an opportunity to explain the actions taken or not taken, as the case may be, before being condemned as unprofessional and incompetent. Yep. Well, that's great. So they say he should be allowed to explain, and then they just drop it. Well, he did explain. Like he literally had an affidavit that they attached to the motion. Hell yeah, brother. Hell yeah. So I don't know what this argument was. That was dumb. Defense counsel had little choice but to question the credibility of the victim. That was his only viable defense. This opened the door to some extraneous allegations, but that does not make defense counsel's conduct something which no competent defense counsel would engage. He was not ineffective. Here, appellant claims his attorney was ineffective for pushing a defensive strategy that allowed the state to introduce evidence of the appellant's abuse against his other daughter. Abuse? Generally speaking, like a general term, not a term of art, abuse. The only abuse would be BW's allegations that I could see. I mean, a lot of it's distasteful, but I don't know, abuse would be the BW's allegations that JS denied. So I guess that are in the same house. The record does not contain the trial counsel's reasons. This is usually enough to rebuff such claim on direct appeal. Well, it should, because it was attached to the motion for a new trial. Putting that aside, the state is unaware what an alternative viable course of action would have been available to the defense counsel. Well, I'm sure that Earl's attorney would argue that it would have been a viable alternative to develop instead of putting it in his opening statement, to develop the facts that it was a small house, that it really couldn't have occurred every night without anybody noticing it, by questioning witnesses instead of by making an affirmative statement. In a case such as this, the only viable defense would be that the victim is falsely accusing the defendant of these crimes. Well, normally, pretty much in any case, the only viable defense is to say that the allegations against me are all false. That's like every case ever. I can't imagine a case where you wouldn't be saying, yeah, all the evidence against me is false. The defense counsel clearly was not expected to go through the entire trial without challenging BW's credibility or giving reasons why she could be fabricating these claims. Juries like to know why. Juries like to have a why people would do things. Juries like to have a why. Just because the appellant's only defense came with this risk does not mean that the trial counsel engaged in conduct so outrageous that no competent attorney would have engaged in it. Yeah. Likewise, we conclude the appellant's counsel in this case was not affected by presenting evidence to question witnesses' identity when identity was the only real offense, even though it may have opened the door to an extraneous offense. Defense counsel was prepared for the admission of the extraneous offense, and in fact, impeached the identity of the appellant made by Portillo in the extraneous offense. Well, see, so in this example, they have defense counsel was prepared for the admission. In Earl's case, he wasn't. So, Also not designated for publication. Another one for Eline. Didn't anybody teach all of these other attorneys Eline's rules for successful pleadings? Always, or never cite DPubs. Why do juries want to know why? I think people in general want to know why. We have creation stories that don't really explain why to explain why. Why does the sky exist? Well, because God created it. How do you do it? Because he's God. He's God. He can do anything. Doesn't really explain anything, but it gives a why. People want to know why. Where did people come from? People were created on the sixth day. Why? So that they could worship God or something like that. People always want to know the why. Jack and Jill went up the hill. Why? To fetch a pail of water. People want to know why. Motive. So if you give someone an alternative reason why, they might accept it. And you wanted to know why. People want to know why. Point proven. A defense counsel must take the facts of the cases as he finds them. Sometimes there are no perfect options. Thank you for that platitude. Thus, the third issue presented should be overruled. Oof. I mean, I'm not saying the state should lose on the third issue, but that was a shit argument. Fourth point of error. Trial court erred by allowing the police officer to testify that he found BW credible based on her emotions and reactions through his interviews. This issue is not preserved. And to the extent there was any error, the testimony is harmless. I'm pretty sure it was preserved. Well, they said it was preserved. Prejudice. Over trial counsel's objection, seems like it was preserved. So, somebody's lying. The appellant next claims that the trial court erred by allowing the police officer to testify that he found BW credible based on both. Not preserved, yada, yada. The appellant did not object to the state's question, seeking to elicit this answer. His objection came after the witness had answered and was beginning to answer the next question. This came too late to be timely. That sounds too late. That does sound too late to be timely. You're pushing it. To preserve a complaint for appellate review, a party must have presented to the trial court a request, objection, or motion that states the specific grounds for the desired ruling if they were not apparent from the context of the request, objection, or motion. The objection must be timely. That is, the defense must have objected to the evidence, if possible, before it was actually admitted. If this was not possible, the defense must have objected as soon as the objectionable nature of the evidence became apparent and must have moved to strike the evidence, that is, have it removed from the body of the evidence if the jury is allowed to consider. In the instances of an objection to testimony where it is reasonably obvious that the question itself is improper, or where it calls for inadmissible evidence, an objection is timely if made at a time preceding the witness's answer. Yeah, it's fucking brutal. If a party fails to object until after the objectionable question has been asked and answered and can show no legitimate reason to justify the delay, the objection is untimely and error is waived. Here, the objection was not timely. The objected to exchange consists of the following. Question. In speaking with BW, did you find her to be credible and reliable? Answer. Yes, ma'am. Question. Why is that? Answer. What I talked to her, defense counsel, I'll object to this last question about the credibility of the witness. Court, it's overruled, counsel. Proceed with some caution. Question by state. You can answer the question. Answer. I felt when I initially contacted her, just the way she spoke to me, she. Defense counsel. Judge, I'll renew the objection to the answer. Same ruling, overruled. Finish your response, officer. So, Now, I'm dumb and just a first year family law attorney, but it doesn't look like he was objecting to this question. It looked like he was objecting to this question. This last question. And then he starts to answer again, and defense counsel renews the objection. Were the extraneous allegations contemporaneous evidence or new? I think it would have been contemporaneous with the old allegations, the extraneous allegation, contemporaneous evidence or new evidence. Boy, all right. So contemporaneous evidence is evidence that exists that is created at the time. So like it's not testimony. Well, so the testimony that was received in court at trial is not contemporaneous testimony. It's corroborating testimony at best, but it's not contemporaneous. Contemporaneous evidence is evidence that is like that shows that you made the statement when you made it, that shows the thing happened when it happened. So like when you call the police and then you could produce the record of that police call, that shows contemporaneous. It's same. It's created at the same time. I might be doing an E-line and making up words like Depop or Depub, but in family law in California, there is a benefit to having some sort of a contemporaneous evidence to show the court it's a thing. It's not testimony, to show the court that the thing happened when you said it happened. It makes it more credible and less likely that it makes it more likely that the thing happened. For example, if now I say 20 years ago WTT touched me inappropriately, well, did he? But if 20 years ago I filed a police report, said that WTT just touched me, that police report is contemporaneous evidence. It shows when it happened, or when it allegedly happened, I should say, right? So then if my buddy gets up on the stand and says, yeah, 20 years ago, WTT touched me too, well, then that's not contemporaneous evidence. That's corroborating evidence given at trial. I hope that makes sense, Tom. I think you're a genuine person. I don't know. We don't get paid to screw in light bulbs. I doubt that. Here's something I don't understand though. He just objected and the court didn't ask for the grounds. That's fucking weird. And they get is like, I'll renew the objection. Same ruling, overrule, like objection based on what? My understanding is second and third hand at best. But my understanding is that there were a lot of allegations made generally by the daughters. There's 3 of them, if my understanding is correct, that there were a lot of allegations that were made outside of trial. A lot of allegations made outside of trial. That's my general understanding. One of the reasons why I don't pay a lot of attention to a lot of the bullshit that people try to throw out stuff about like Turtle Boy to me, or about Kate to me, or about other people who are engaged in ongoing litigation like Chili, right? And I don't pay attention to all of that shit that's getting said outside of trial or done outside of trial, because you don't know what's going to get presented at trial. people might be just fine lying outside of trial and not comfortable lying at trial, because maybe there's some document at trial that's already been presented that would show them to be a liar, or maybe they know the defense that or some evidence that the other side has, rebuttal evidence, just in case they do try to lie. So I don't pay a lot of attention to the stuff that's said outside of trial on anybody's case, because who knows how much of it, if any, is bullshit. Yeah. Yeah. And that's why I didn't pay attention to it. That's why people would be like trying to tell me, they'd be sending me emails and DMs and shit about it. And I'm like, I don't fucking care. Like, let's wait to see what comes at trial. That's the shit, right? We know. Here's the question on its face. Here, the question on its face seeks to elicit the officer's opinion to the victim's truthfulness. The defense counsel waited for the witness to answer. The state had asked another question, and the officer began answering the second question. This objection was not timely. Well, if this objection was to this question, I think it probably was timely. No, he wasn't tried on the shell thing. There was no case about the shell thing. So no. But nice attempt, WTT. I appreciate the attempt. If you went to trial on the shell thing, then I would limit my knowledge and understanding to actually what was presented at trial. Like I said, like you may have noticed, I know things, I've heard things about allegations that were made outside of trial in this case, but I ignore them. I don't seek them out. So again, I think this objection, if this objection is to this question, I think it was timely. I think it was timely. Well, yeah, that was stupid because he didn't show that. And he was also going to get what was her name, Kim Og, fired or some shit, because I think she was part of the Earl conspiracy, anti-Earl conspiracy, and he never got her fired. She lost her re-election, but she never got fired. So I'm curious now, and you know what happens when I'm curious? I am going to look this up. What is their actual objection? Motion for new trial. Did I go too far? Did I go too far? Well. Looks like Earl's attorney was slicing the turd quite thin as well. So this is a technically true statement. And as we all know, technically true is the best kind of true. The state was able to present a direct comment on the complaint's truthfulness from an expert, blah blah blah, and who found her. So they're smushing. So Earl's attorney's trying to smush. Earl's attorney wasn't objecting that this part got in and the finished response got in. He was objecting that this part got in. And this objection is probably too late for that. Not only timely but correct. He was asking the officer what someone else thought. What are we drinking tonight, Tom? I don't understand. The state's attorney was female, so she was asking the officer what the officer thought. Did you find her, in speaking with BW, did you, the officer, find her, BW, to be credible and reliable? Which should have been objected to. You don't object. You don't object to objections. You argue them if the court allows it. Sometimes the court doesn't allow speaking objections. You just have to state your objection, and then if the court wants argument on it, the court will invite you to argue on it. This looks weird though. Appellant did not object to the prosecutor question, but asked and answered, and the prosecutor had passed the witness. That seems a bit different. 618. 618. I just noticed that. 618. I just noticed that. Oh, you're not seeing this. I was on that and now on this. 618. When the prosecutor passes on a witness, what that means is the prosecutor says, I'm done, no further questions. Okay, so this was the exchange in Legrone versus State. Although you have not made an arrest of this defendant, do you base your opinion as to his reputation on informant information and on talking to other individuals? Answer: informant information and other officer information. Question: have you ever talked to young girls about his reputation? Answer: yes, I have. Prosecutor: will pass the witness. Defense attorney: we're going to object to any further questioning in these last two lines as being outside the scope of reputation testimony. Court: he's already passed the witness. I'm assuming he's through. Okay, but I object to the last two questions. The court overruled. Yeah, I mean, there's a huge difference between this. I mean, this is obviously, but if it takes this much, if it takes actually two questions asked and answered and then passing the witness for it to be too late to object, I don't know. I don't know. So even if the appellant preserved his claim, any error in admitting the testimony is harmless. Well, so they live in a trailer, bro. They live in a trailer. So number one, you assume that the door has a lock, and or if it has a lock, that the lock works, which are some pretty big assumptions to make, right? All or none of those things, from my understanding, and again, this is second or third hand, they were not living high in the hog. There was some abject poverty going on here. These were poor folk in poor folk Texas. So they might not have even had a doorknob that worked. You know what I'm saying? The appellant analyzes this issue as though the officer was testifying as an expert under Rule 702. Well, let's look at Rule 702. Rule 702, expert testimony. That's federal rules of evidence. Texas rules of evidence. So there's two kinds of evidence that you can get. There's percipient witnesses, people who see, taste, touch, smell, hear. Those witnesses, they could tell you what they experienced. I saw this person do that. And then you have experts, and expert witnesses can give you their opinion. about what it was. Yes, in my professional opinion, he died from 2 stabs to the heart. And what's your expertise? What's the base? Oh, I'm a doctor. I have this many years of experience, blah, 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 right? So if you're eliciting opinion testimony from someone, then they're an expert, because you can't elicit opinion generally speaking, you can't elicit opinion testimony from percipient witnesses. I mean, if you establish, like, you could ask your mom, in your opinion, did your son sound like he was upset? Oh, some rape chases going on. They're not interested, apparently. Fabio's getting a little slow. There's some flight happening there. The ladies were like, "No, thank you, sir." He doesn't really take no for an answer. So yeah, so it would be expert. If you're asking for an opinion, to testify in the form of an opinion, then it's expert testimony. Oh, you can't see this. Opinion testimony. The state is not so sure that this is correct. Well, the state doesn't know if they fucking called him as a percipient witness or an expert witness. Do they call him up to give his opinion, or do they call him up to testify about the facts? Well, let's see. Did he fucking see anything? No, he wasn't there 20, 25 years ago. So what is he going to testify about if he's not an expert? Like, what kind of game are you playing, dude? What is he going to testify about? Did he do crime scene analysis? Did he take a semen sample? What is he going to testify about, if not expert? And even then, a semen sample would probably require expert testimony. Crime scene examination would be expert testimony. How can he be anything other than an expert witness? Jesus. Like I get it. You might think I'm retarded, but this attorney apparently thinks that the Court of Appeals is retarded. The state is not so sure this is correct. The officer had a history of investigating these types of cases. However, his basis for saying he found her credible and reliable was purely based on how she spoke with him over the phone and the amount of emotion that she displayed while she was speaking to him. It was an opinion. It was an opinion. If he had testified that when she spoke, you could hear her voice waver and crack. Did it sound like she was emotional? Yes, it did. Is that opinion? Probably not. But was she credible? Well, based on her emotional state. Yeah, I mean, this sounds like an officer responding to the same emotional signs of credibility that any person would. So anybody gets to be, so you could ask any opinion. Like, so you get Bob up on the stand. Hey, Bob. Do you think that that BW is credible? Nope. All right, cool. Thanks, Bob. Let's get Joe up on the stand. Hey, Joe. Do you think BW is credible? Nope. All right, thanks, Joe. So 3, the ultimate conclusion of whether a victim was credible in his opinion might have been objectionable, but the testimony about her demeanor while speaking to him would have been admissible. Okay, but he's not giving testimony about her demeanor. He was giving testimony about why he found her to be credible. Caudill asserts that it was error to permit Julia Davis to testify that when Caudill told her that Lynetta White had said, "Help me, why are you doing this to me?" Caudill was laughing and using a mocking tone of voice. We disagree. A lay witness may express an opinion as to another person's demeanor. Demeanor. One of these words is not like the other. One of these words just doesn't belong. Demeanor is not credibility. Demeanor is not credibility. So Caudill was laughing and using a mocking tone of voice. So Lynetta White didn't say that Caudill was credible. She said Caudill was laughing and using a mocking tone of voice. Conjunction, junction, what's your function? Like, they're pissing on my leg and telling me it's raining. Wright's statement that Watkins was, quote, scared, end quote, and, quote, not able to think, end quote, was rationally based on Wright's perception of events transpiring before him, specifically watching Watkins running for his life while being attacked, and was therefore helpful in explaining Wright's perceptions. Okay. Again, credibility is the purview of the finder of fact. In this case, since it was a jury trial, it was up to the jury to make a determination of credibility. You can't get an expert up there to say this person was credible. Demeanor is different than credibility. Remember how I said that, I used an example of a mother saying that her son, sounded scared or whatever. I don't remember exactly the example I used, and I said that would probably be percipient testimony. That probably wouldn't be an opinion, because you could judge someone else's emotional state, right? She looks happy, she looks sad. And if you need to develop it, you could ask why. Well, she looked happy because he was smiling, and the smile touched his eyes. He had the crinkles in his eyes and a glint in his eyes, and he was jaunty as he was moving, and yada yada. Right? He looked happy. Not an issue. He's credible. That's an issue. That's a fucking issue. I've read a lot of cases back in law school where people would try to get testimony in from experts that would speak to the ultimate truth or falsity of the case, the ultimate point of the case. Like where the expert would say, he could not have committed this murder, right? Which would be like, that's what you want the expert to say, but the expert can't say that. The expert can say things like, in my to a degree of medical certainty, the killer would have to have been, 6'4" tall and right-handed in order to have stabbed the person. And then you could be like, well, is my client 6'4" and right-handed? No. Oh, see, and then you could leave it out there for the people but you can't have them say, he could not have committed the crime, right? Accordingly, a witness may not characterize the defendant's demeanor when the characterization is tantamount to a comment on the defendant's credibility. Well, holy shit. Accordingly, a witness may not characterize the defendant's demeanor when the characterization is tantamount to a comment on the defendant's credibility. Are these people even trying? Josh Abrams. What are we talking about Josh Abrams for, Taze? Jesus fucking Christ. It says it there in black and white. They cited the case. A witness may not characterize the defendant's demeanor when the characterization is tantamount to a comment on the defendant's credibility. Here, it was a comment on the defendant's credibility, or on the witness's credibility. It was a comment on the witness's credibility. And then it was supported by a characterization of the demeanor. However, regardless of whether the officer was testified as an expert under 702 or 701, courts have interpreted Schutz v. State as also holding that a lay witness is not permitted to offer an opinion other that another witness is truthful. Am I reading the right brief? Page 34. I gotta say, it again. Again, this is the second time that they've just flat out said that the defense was right. I mean, basically flat out said the defense was right. Whoa. But here again, here the appellant was not harmed. There was additional testimony about the general topic of whether the victim was truthful in her allegations. Additional testimony about the general topic about whether the victim was truthful in her allegations. But there was also counter evidence presented that would have suggested that she was not truthful. So don't you think it's helpful to decide that as the proponent of her being a truthful witness, that, I don't know, a detective is allowed to say, yeah, in my experience, he's already laid out. By the time he got to this testimony part, he's already laid out. I've been doing these kinds of investigations for 14 years or whatever. I've done X number of these cases. I have all these degrees and experience and this and that. I'm an expert. I investigate this stuff. I'm an expert. And she's credible. Don't you think that that's a pretty significant boost to have to the pro BW is not a liar side? The pro BW is honest and credible side? Don't you think the defense would prefer not to have that? I think so. Here, the appellant was not harmed. There was additional testimony, blah, blah, blah. The appellant put on two relatives to testify that BW was not truthful. Well, gosh. One relative, after testifying that BW's allegation changed as it was originally made, stated bluntly BW lies. Well, boy, BW lies. Yeah, stated bluntly BW lies. After testifying that BW lied, i.e., her story changed, stated bluntly BW lies. The appellant's former wife testified without objection to her struggle at the time of these events as to whether to believe her husband or her own daughter. That so much similar legitimate evidence was introduced about BW's credibility weighs against any harm on this issue. Let's see what page we're on. 600. Mosquitoes are coming out. And I don't have pants on. So here they asked, do you think he's credible? The court said the court said the jury will be able to decide the credibility. So the court sustained it as credibility. So the state, thinking fast, said, "Do you think the child was lying?" They said no. Counsel said objection. Court overruled it. Counsel said that's comment on the credibility of the witness. Overruled. So here, first, he responded with the child's lying with a concise no. I don't know, man. Immediately before the question, the trial judge sustained an objection and said the jury will be able to decide the credibility of the witness. Why would he let the second one in, though? I don't get it. The state did not emphasize or mention the objected to portion of Hicks' testimony in its closing argument. Okay. His outcry statement supported his testimony. Contemporaneous. Interesting. I don't know what to think about that, so I'm not going to opine on it. Also, BW testified trial over a 2-day period. She was fully subject to cross-examination. Thus, the jury was able to observe for itself her demeanor and other sides of credibility for itself. This also weighs against finding of harm. Okay. As in a prior CCA case, the complainant who'd made out of court statement was in court, had testified on direct cross-examination, was available for further examination, all before a jury capable of observing her demeanor while testifying. Final fact of the ways against harm is common sense concept that the officer's statement was obvious to everybody in the room. He was the officer who investigated the case, presented to the Harris County District Attorney's Office. It'd be odd for him to have done so if he did not think the BW's version of events was credible and reliable. I don't know, man. I don't know. I guess Texas thinks that that's not, maybe that's not prejudicial to have the officer testify that he's an expert and he investigates these all the time and he found the witness to be reliable and credible. Boy. Ugh. In short, this one isolated bit of testimony amongst 2 days of extensive testimony that was both admissible and relevant to the case did not cause non-constitutional harm. Reply to appellant's fifth point of error. The appellant claims he was denied the right to a fair jury trial because his trial was subject to outside influence of the jury. See appellant's brief at 57 to 61. That's all the crap going on. The appellant conflates whether an outside influence was brought to bear on the jury and whether the jury engaged in misconduct that would require the granting of a new trial. The trial judge chose to disbelieve the affidavits attached to the motion for a new trial, and thus the court properly denied the motion for a new trial. Furthermore, an outside influence is not a ground in and of itself for granting a new trial. District court's ruling on a motion for a new trial is subject to an abuse of discretion standard. The trial court is allowed to disbelieve even uncontroverted affidavit testimony, as is relevant here. A new trial must be granted for several types of juror misconduct. One of these grounds is satisfied whenever the jury receives outside evidence that it uses in its deliberation. Another occurs if a juror converses with someone about a case. Well, I think I don't. Again, the court can choose whether or not to believe it happened, but there was all that testimony about Dougie Fresh getting kicked out because he was talking to jurors about the case. Now, in Dougie Fresh's defense, Dougie Fresh has always maintained that he was talking to the juror about horses. And you get to determine whether or not you believe Dougie Fresh. I don't. The state uses these examples because they seem to be the types of misconduct to which the appellant is alluding, but as he has filed the issue solely, he has briefed the issue solely as one of whether there was outside influence. He does not specifically state the type of misconduct which he believes that he has proven. Texas Rules of Appellate Procedure 38.1. And what number are we looking at? Subdivision I. Clear and concise arguments, but okay. Okay. Rule 606B bars juror testimony or other evidence offered to impeach a verdict, except when, as relevant here, it pertains to an outside influence improperly brought to bear upon any juror. An outside influence is improperly brought to bear on a juror if it is done so with the intent to influence the juror. The existence of an outside influence under Rule 606 does not, however, mean the new trial should be granted. It just means that certain juror testimony is admissible to prove one of the bases for jury misconduct. 606B does not purport to redefine juror misconduct, nor does it alter the grounds for obtaining a new trial in criminal cases. 606B and 21.3C work together to define jury misconduct and how a defendant may prove the existence of such conduct. 606B defines what evidence is admissible in proving jury misconduct, that is, evidence of outside influences improperly brought to bear upon a juror, while 21C limits that permissible evidence to that which is relevant to whether the jury verdict was a fair expression of the juror's opinion. For those of you listening, once again, I am masturbating furiously. So these are mandatory grounds, but are there any non-mandatory grounds? What about this one? Why are we limiting it 21.3C when there's 21.3F or 21.3G? Are we slicing the turd thin here? Here, the appellant refers to several affidavits purport to show things done that might have been done with the intent to influence the jury. For example, one affidavit claims that someone called the appellant a quote rapist and sex offender end quote within earshot of the jury. The trial court was fully within its rights in disbelieving the affidavits, which is adequate to support denial of a motion for a new trial. The trial court did not have to believe the affidavits, though they were uncontroverted and admitted without objection. But also, the affidavits, while they might show attempts to influence the jury, do not show actual jury misconduct. There are no affidavits from any jurors indicating that, for example, any outside evidence was actually considered in their deliberations. If any outside influence had no effect on the jury's verdict, then no misconduct could be proven. Sorry, I was reading that. I don't know why they're citing that. Here, the appellant did not show any jury misconduct, and thus the trial court properly denied the motion for a new trial. So, Coiler versus State is a 2014 Texas Court of Criminal Appeals case. And they're citing at 129 to 130. At 129 to 130. Once again, furiously masturbating. Citing Coiler versus 8. Outside influences must not be brought to bear on any. I don't think coil really helps. Coiler. Collier. An outside influence was improperly brought to bear on any juror. Hmm. Interesting. And by interesting, I mean probably not interesting to you, but it is in fact interesting to me. And we're looking at 431. 431. Let's see if Macquarie helps. And do we have a page number on Macquarie? Of course not. Still just furiously masturbating. I'm sorry. Technical issues of the law are never really fun. I sit staring at computer screens for hours at work. It really would have helped if they had put a page number on their citation. Really would have helped. Close tabs, because I'm getting lost. Always reopen tabs, right? Well, let's go back to this. All right, to be entitled to show to be entitled to a new trial because the newspaper article, the defendant must show he was injured or prejudiced by the jury's alleged reading of the article. See, I don't think that's from 82. And the stuff that I was reading, like this Macquarie, is from 2012. So in 83, the Texas Supreme Court adopted 606B. 3 years later, so in 86, no, so civil and criminal rules of evidence merged. So 606B, the current version of 606B, came into existence in 1998. And these people are citing a case from 1982. So they're citing a case from 1982. Again, this is according to the Court of Criminal Appeals. In 83, Texas Supreme Court adopted Rule of Civil Evidence 606B. In 1998, the Texas Rule of Evidence 606B incorporated the civil version and the incorporated civil version of the rule. So why is the state citing a case from prior to 606B if we're talking about 606B? I don't understand it. And once again, I want to remind everybody, I'm not a Texas attorney. I'm a first-year family law attorney out of California. And this particular brief, the state's brief, is not going to be considered by the court. I'm really reading it, by the way, so everybody's caught up. Just so I can have an idea of how the of how the Court of Appeals might rule, and so I could maybe synthesize some of this into something sane, into an opinion on how they're going to rule. Sixth point of error. Hey, folks, we're more than halfway done. Erred in considering the jury deliberation in its decision, has not preserved this claim, and furthermore, the rule he cites does not support this. Rule 606b explicitly prohibits post-verdict testimony about a juror's mental processes to impeach the verdict. The rule bars testimony from a juror or evidence of a juror's statement about the subject. It does not prohibit testimony or other evidence from other parties about this topic. Rule 606b permits non-jurors to testify about their personal knowledge of juror misconduct and the introduction of circumstantial evidence to the same effect. Here, the trial court gave his reasons why he believed that the jury was not affected by an outside influence. He gave his reasons from events that occurred at trial. In 2 paragraphs, he said the following: but there are numerous attempts to influence and intimidate a jury that I believe were absolutely unsuccessful. So the trial judge admits that there were numerous attempts to influence the jury. That's bad. This is the hardest working, most diligent jury panel I've had in 37 years. They were attentive and intelligent. Wouldn't prove that. I can't bring it in here. It's not part of the trial. But you're basing your decision on it. So that's kind of cool. At the end of the case, after Mr. Warden agreed to sentencing, I went back into the back to tell the jury the outcome of the sentencing because they thought they were going to do the sentencing. When I walked in the jury room, I was stupefied to the point I actually took a video of what they did. My first video in my 37 years down here of jury work product. They had papered the room with giant pieces of white paper, different colors, charts, diagrams, a list of witnesses, and dates to show the diligence they did over multiple hours of deliberation. This exchange sounds like the judge is not considering it as evidence when he says, wouldn't prove that. I can't bring it in here. It's not part of the trial. It sounds like he's not considering it, but then he goes on to consider it, right? This sounds like he's just giving the parties extra information about why the trial was fair. I'm not going to call it evidence. I'm just going to call it information. I'm not giving you evidence about why the trial was fair. I'm giving you information about why the trial was fair. Don't you see? It's information, not evidence. Gee, guys, how could you be so dumb? If the appellant had objected, the trial court could have clarified the matter. So did he have to object at that point? I don't think so. The judge was making the statement as the basis for his ruling. However, he did not, and thus appellant has waived any complaint. So does this say that he had to object to the trial court's basis for the ruling before appealing? So would he have had to do what? A motion for reconsideration? No, that wouldn't be applicable. I don't know. Well, in order to appeal, so generally speaking, the rule is like you have to make your objection. You have to preserve like objection to evidence, objection to testimony. But objection, where I'm stumbling is objection to a judge's. So normally the order is appealable, right? You don't have to go back to the judge to appeal the verdict or the order. Maybe I'm applying too much family law. I don't know how the court's going to rule on that, because it doesn't seem right. It doesn't seem right that maybe they had to do a bill of exception. I think they didn't put it in the. I thought they did. Hmm. Hmm. I thought so too, Tom. But Texas has these formal bills of exception to complain about a matter that would not otherwise appear in the record. But I guess these would appear in the record. So in a civil case, neither a formal exception to a trial court ruling or an order, nor a signed separate order is required to reserve a complaint for appeal. Neither a formal exception to a trial court ruling or order. So I think this is how it gets in. Because this is the court was making an order or ruling on the motion. The court was making a ruling on the motion for a new trial. And as part of the ruling, the court that's all I could think of. And I think the state's position is you had to actually object to the court making that part of the rule, which I've done, not in a criminal context, but in a situation where the court was issuing a civil harassment restraining order against my client. In the middle of it, I started basically vordeering the court as to, did you find this element was met? Did you find this element was met? And by the end of it, I got it all straightened out, and my client walked out of there without a civil harassment restraining order against him. And I guess I would have objected. So maybe, yeah. I mean, I, now that I'm thinking about it, I would have objected with the court saying that stuff. So maybe they should have. I normally trust my gut on it, so maybe they should have. Again, they keep citing these unpublished decisions. Stat, someone get Eline on the phone. It was Watkins v. State 0377. All right. And we are looking at number 2, whatever number 2 is. This is dealing with the erroneous admission of evidence. Admission of evidence not disclosed in discovery. I don't know what this has to do with anything. We're at 2. Is there some other 2? What the fuck are we talking about? Because Watkins did not object to the PSI, he cannot complain at the trial court. Because Watkins presents the investigation report. So I'm guessing what's happening here is at trial there was a pre-sentencing investigation report which makes factual assertions and would all be hearsay. And so normally what you would do is you would object to it, and the person who actually wrote it would have to come up there and testify about it, and that way you could cross-examine them on it. But this isn't the court making its own findings. This is where there was evidence being introduced. Well, I guess it's in the sentencing phase. So he pled to it, and then the court took judicial notice of it without objection. I have to pee. I've been drinking a lot of water. All right. I also took the opportunity to spray myself with bug spray because nothing's worse than getting your balls bit off by mosquitoes. All right. Yeah. I'll start. We're starting over at the beginning, folks. Yeah. Well, so I think there's a couple ways of doing it. I know what they're talking about in here, whether it's statutory or constitutional, but they're talking about the discovery part of it. That he didn't object to it, and yeah. Anyway, furthermore, the judge, considering charts observed on the walls and seeing how much work the jury had done, does not run afoul of Rule 606. Were they talking about 606? I got to find out. Rule 606. How about just 606? And it's Rule 606B. We talked about a little bit. Okay, footnote 5. Where's footnote 5? Where's footnote 5? Then, without delving into the jury's deliberations, the court must. Okay, so that's the first 606B. That's the second 606B, I should say. The consideration of evidence of the jurors' deliberations in evaluating the claim is prohibited, and by well-established case law, it requires reviewing court to conduct without delay. Improperly consider the jurors' deliberations. Improperly considered them. Improperly considered them. Improperly considered them. I don't remember it being improperly considered. Evidence of the deliberations are not admissible. Okay. Consideration of evidence is prohibited. The consideration of evidence is prohibited. Ah, fucking Woodman. And that's Woodman at 431. Fucking back to this bullshit. 431. 431. All right, I've just been informed that I have overshot my WAD. My WAD is overshot, and I have been instructed that I'm done. I may pick this up tomorrow, and we can go through some more Woodman v. State. I know that's all 48 of you, but no. Sorry, got to go. We're going out for Italian food tonight, so I gotta clean up and get going. Thanks for watching, or not, whatever. Have a great day.